Hello, 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 everybody. Brendan here with Thought Riot Podcast, coming to you live on this beautiful Wednesday, April 10th, 2024. I couldn't think of a better day to have a Bryan Kohberger, Idaho, for hearing. Let's get into some madness. Let's see what we can get into here. Malia should be here any moment. All right, I am just getting our marketing stuff out real quick, paying attention to Judge's YouTube. I'm kind of surprised he only has like 20,000 followers. I hope everyone's having an awesome day today. For me, it started off kind of stressful with some work-related stuff. A little bit of chaos never hurt anybody, though. Welcome, everybody. Welcome, welcome. I see you all. Hang on here. So shares. I am looking forward to hearing some experts, if I'm being honest, you guys. That's what I'm hoping for more than anything, is to hear some experts today. I think that's something that we were starved of not yesterday, the last hearing. I need some oxygen and caffeine. ADHD's dream. Oh, wow. I sound great. Is this Fiji apple? I think this is green apple cherry. I don't know if I've had the Fiji apple Celsius, but I don't take any medication for my ADHD, you guys. So when I need to be able to think straight, like when I'm having really important meetings or anything important for work, okay, where it requires my attention and I got to focus on a single situation or whatever. Celsius is how I manage that. So caffeine. And it works for me. It doesn't always work for everybody, but all right, where are we at? How much time we got? We got 8 minutes. We should set some bets here. Is Malia going to get here in time? Someone was saying the other night, I need to go out of my way to be late for Malia, but then we would just have 2 people late. So the whole show would just get started late. I can't be late even if I wanted to, you guys. I do not have it in me. I'm just not that type of person. It literally stresses me out. Yeah, I'm late sometimes. I think everyone's late sometimes, but it stresses me out big time. And it's only in certain extreme situations outside of my control. I think everyone's late sometimes. Man, all right. So, are we going to hear experts today? What do you think? Are we going to hear from experts today? We better be hearing from experts today. I'm telling you. That is my biggest hope right now, is that experts. No, we aren't brother and sister. We've just known each other for a long time. Like, I don't know, around like 1995 or something. I was, working on a corner, and Malia just, out of the kindness of her heart, picked me up and was like, hey, I have a show idea that I want to start in 2024.
Yeah, I was definitely driving at toddler age.
Appreciate that. Yeah, I think the jabs are fun though. I feel like they're always good faith and good hearted. Although I've noticed some people are just more sensitive than other, and I don't mean that as a stab, but like, man, there's some of our content where people will respond to us and be like, oh my gosh, he is so abusive. We talked about this quite a bit in length, to the point that it's gotten old, but it's always surprised me because I go out of my way to listen to feedback. It's really important. I am not one of those people where someone gives me information or feedback and I'm just going to blow it off. Like, I want to know what someone's seeing. You know what I mean? Every single time I've gone and looked, I'm like, oh my gosh, that's me at like 10%. I don't even think I've been like
10% abuse.
Yeah,
that's you 10% abusive.
Yeah, right. No,
you need to be way more abusive.
You call that abuse? Wait till you see me at 90.
Oh my gosh.
No, I mean like aggression. You know what I mean? Like
aggression,
anger. Yeah, like what I mean is, obviously there's no physical abuse or verbal abuse, because verbal abuse is usually based off of words that are saying. So obviously they're talking about like character and tone and things like that. So when I watch my character and tone, I feel like I'm reserved. I feel like I'm at like 10% argumentative aggression, you know? Does that make sense?
Yeah.
Because I feel like I could be much more conversationally controlling, not in an abusive way, but like normally there's a leader in a conversation. In the business world, somebody leads the conversation, okay? And I don't feel like I've seen myself even a little bit like at 25% there.
It's definitely not gonna pop up till 6, just so you know.
Yeah, I just checking.
And maybe even a little bit later than 6. It's never been early. But yeah, we should definitely keep it on refresh.
Yeah.
Because it suddenly pops up and we don't want to miss a second.
And they already pop it up after they've done the introductions. The last time everyone's already sitting there, like it's literally right when they're starting to talk.
I know.
You
so
can
you
miss something,
right?
Yeah.
You need to be tuned in at that moment.
Yeah, I gotcha.
Because they're already beginning right now. I think I got water in my ear. I might.
Gosh, I got something in my eye. My eyes are.
You got something in your eye? I got something in my ear.
Like both eyes. Both my eyes went super blurry, like diabetes blurry, but that's not what it is. No,
I was about to say.
I think like hair product or something got in my eye. Yeah. I am passive. I'm super passive.
No, you are not.
Yes, I am. Okay. I am beta max. Okay. The max passive.
Not in a conversation.
Yeah, I am.
No.
Yeah, okay. What do you think? Are we going to hear from experts? That's what I was talking about. Like we were just chopping it up, but I was talking about a little bit about what we can expect to see today. And look, if we're talking about the polling at all, dude, there better be experts.
Yeah, so last hearing, it was a total mess. Hopefully we'll see some redemption this time. This is going to be about the same exact topic. Them going over the jury survey. We didn't hear from the expert that actually wrote the questions last time, and I'm hoping this time we will refresh.
Yeah, I got
it should be going live literally any second. Nope, not yet. You should go ahead and have it set up to share.
It is. It's right here.
Okay. I'm just saying I would go ahead and put it in the middle on the screen or something.
Okay.
Just in case, and then we can switch over.
No, I'll just wait until it pops up because I have to click it over to full screen. And in the middle, it doesn't.
Okay.
It's going to reflect what my page is showing. So I can't click over to the
What are you doing?
analytics
Get
in
back
Studio.
over. It's going to start any second.
I get it.
I really hope we hear from that expert, though, because I'm of the mind that those were all very public. Like, it was all very public information in those questions. Like, there's no doubt about that at all. It was everything that was in the PCA. It was, like, I think it was only like 3 questions that weren't in the PCA, but they're very, very known, not facts, because 2 of them, I think, basically Bill Thompson alluded to that they were false. The only one that I think was accurate was that he was arrested at his parents' house. And that is the only one that's not in the PCA.
Yeah. Yeah. Are we live yet?
I told you they're always a little bit late.
Yeah, I don't doubt that at all. Dedicated. Okay. Yes.
Come on, Judge John Judge.
Right.
I wonder if like being a judge runs in his family.
There we go.
Yep. Here we go. The sound isn't on.
All rise.
Oh.
Thank you very much. Please be seated. Good afternoon, everybody. Hey. On the record, please. Thank you. We are now on the record. This is State versus Bryan Kohberger, case number CR 29222805. Mr. Kohberger is here in the courtroom, represented by Ms. Taylor and Ms. Mathis. We've got Mr. Thompson, Ms. Jennings representing the state. Can you hear me okay?
Yes.
Yeah, okay. I think we have Mr. Nye and Ms. Beatty on Zoom. Anybody else on Zoom? Ms. Taylor?
No, Mr. Logston is not going to be on Zoom today. He had the other hearing.
Ms. Beatty made it apparently. So, and I have also, you have Mr. Edelman, Dr. Edelman here today.
I do, Your Honor.
Okay. Great. So I think what we're doing today is just a continuation about the questions, particularly on the surveys and where we go from here. You did drop off a sealed exhibit, right? Anything to say about this, or just?
Yes, Your Honor. That sealed exhibit goes with one of our discovery requests, that the exhibit that outlines what we're requesting has to be under seal. And so I had to hand deliver that to the court. A copy was hand delivered to the state. It is not up for discussion today.
Okay, great. Thank you. One other thing to just tie up is the order unsealing the state's motion for order prohibiting contact with prospective jurors. There was a discussion between both of you about redacting a particular sentence, maybe last time, and so that we were going to take care of that.
I didn't. Ms. Taylor indicated that there was a sentence she thought we might want to consider redacting. I haven't heard back on that, and I know that she's been busy on other things since the 6th.
You want to just talk to each other for a second?
I understand the microphones in the courtroom are very sensitive. Perhaps we should do this after court today and go ahead and do the testimony of Dr. Edelman first. I'd be happy to talk to the state afterwards.
Right. All right, so is that where we're starting now?
Yes, Your Honor.
Actually, Judge, I think we need to discuss some preliminary matters first.
Okay, go ahead.
As Your Honor indicated just a moment ago, this is a continuation of where we were on the 6th. And the issues on the 6th and the issues that we have here today is first, whether there was a violation of the non-dissemination order. And if so, where do we go forward from that point? And I think it was clear from our discussions on the 6th that the fact-specific questions did violate the order. I realized that the defense would like to proceed with those questions. That's perhaps an issue for today. But I just wanted to define what we're looking at today, because about 10:45 this morning, we got what was up on the screen there, a PowerPoint that apparently Mr. Edelman prepared. And as I understand, I don't think Ms. Taylor got it until sometime this morning herself. That's the information that I was given. And we have concerns because a large part of this PowerPoint deals with the issue of a change of venue itself, which is we are not prepared to address. It is not before the court at this time. It is premature. And I don't think that it should be part of this record as we proceed forward today. And so the state took a copy of preparing a printout of the PowerPoint. It doesn't take long to look through it. Perhaps the court might want to take a look at that before we proceed, at least with eliciting things from the PowerPoint. And I realize it's last minute, but the last time that we presented something to the court in advance, Ms. Taylor complained profusely. And I realized it was only 10:45 when we got this today. And so we just figured we would raise it with you now.
Okay, thank you, Mr. Thompson. Ms. Taylor?
Your Honor, I would disagree with counsel that the court made a determination that we violated the non-dissemination order. In my mind, that issue is very right for the court today, as is where do we go from here with the survey? Dr. Edelman has made himself available in court to explain the survey, the process of the survey, why it works, how long it's been used, how widely it's used, and what it doesn't do, and what it does do to present the court with some options to make a decision where we go from here. Whether the court decides we violated the non-dissemination order or not is up for discussion, and we're prepared to further argue that, but we think you need to hear the testimony first. As far as this PowerPoint, I had access to Dr. Edelman yesterday afternoon, and we worked on it late. I didn't have a final copy to give to the state until this morning. So they have it. We are not arguing venue now. We're talking about survey and how that relates to our change of venue motion. We know we're arguing the venue change later, but we have work that we still need to do. And that's where we are today, and would ask to present our PowerPoint and present our testimony with Dr. Edelman as we've prepared to do.
Okay. Yeah, so
Actually, our Ms. Taylor still has a copy of the PowerPoint that made available to the court.
okay, so seems like this happens to me in this case that there's an argument about whether I should go ahead on something or provide some information that I don't see yet. So I feel like sometimes I'm making decisions that I'm in the blind here. So I'm gonna look this over. Any problem with that, Ms. Taylor?
Well, Judge, give me just 1 second. Your Honor, the purpose of the PowerPoint is to inform the court about the questions in the survey and the purpose of them. I can tell the court that showing up every time we want to have a hearing and have to fight to have the actual hearing is something I haven't experienced before either. There is nothing in that PowerPoint that the court can't hear today when making the decision about where do we go from here, and did I violate the non-dissemination order. There's just nothing wrong with the process that we're doing here, and you're continually being asked to say there's something wrong with what we're doing. We're 10 after 4. I have a witness who's traveled here today, and we're ready to go.
All right, Your Honor, just to clarify, as we made clear the last time we reported, we are not saying Ms. Taylor herself violated the non-dissemination order. We're saying that the people who prepared the survey and disseminated the survey and called citizens of Latah County with those fact-specific loaded questions violated the non-dissemination order, and they are agents of the defense. So I don't want this to become personal between Ms. Taylor and myself. We are not alleging Ms. Taylor has done anything wrong. We are dealing with reality that this survey was conducted on, as we understand it, 400, I'll say, innocent citizens of Latah County who were force-fed information that they may or may not have had about this case before they were called by the survey takers. And they are loaded questions. Some of the questions are factually wrong. They simply aren't true. That's what we're here about.
And that's what we're prepared to address, Your Honor. That's why we have a witness here. And if there's violation of the non-dissemination order, it's me. I'm the one that's bound by it. And the court just needs to hear about this process instead of hearing the conclusion that the state wants the court to reach.
Number one, I'm past that. I'm not going to violate you. I mean, this was a communication problem with Dr. Edelman not getting the order. One of the things I think that maybe you need to clear up, not for counsel, but maybe the public, is that one of the terms in that, and this is in the ethics, right, is what is the public record? Public record is not traditional media. It's not social media. It's not what anyone might say in public. Okay, that's the problem that we're kind of balancing here, because the public record is case that is available to the public in this case. I mean, I think we can all agree with that. No?
No,
You think the public record is whatever the media pumps out?
Your Honor, I think it's what's in the public, and what's in the public is derived from the affidavit that supported probable cause to arrest Bryan Kohberger. That's the first document that the court finds in the whole cases of interest on Idaho State Supreme Court's website. That document has a ton of information in it that relate to the questions in the survey for the case-specific questions. So that document became public record, and that was spread far and wide all over the place and reported and interpreted repeatedly. That's the public record. That's where the questions came from. There's no violation of the non-dissemination order if that's what we're going to talk about today, but I think the court should hear from our witness and understand a little bit more about this survey process.
I'm very interested in that. I told you last time that I'm interested in what he has to say about this, but so you're saying that the public record though comes out of the case, right? That's public.
I'm saying in this case, that's exactly what happened, Judge. I don't want to argue the finer points of what's in the media, but I'm saying in this case, that's exactly what happened. That affidavit's there, and this court knows we have a ton of things that are filed under seal and more things that are not filed under seal. But that affidavit that began this case has been shared far and wide, and media stories have generated. When you understand how Dr. Edelman does his work to determine if a survey even needs to happen, you'll know where the information came from.
Okay, so I'm understanding, okay, the initial probable cause affidavit is part of the public record. And you're saying, well, that got spread, okay, by the media, as you would expect. And that's something that could be concerned. So what I think maybe, I don't know, what Mr. Thompson is talking about though is information or questions that were not in the record. And so what I'm nervous about this is I don't want to continue to spread things out that shouldn't be spread. And so I don't know what's in the slides, but if there's information in the slides that are not in the public record, that really have not been disseminated generally, then I mean, I don't really want to spread it. None of us want to spread it more than necessary.
Well, last week in court, that was right inside the courtroom. That all became part of the public record. The 9 questions were stated repeatedly in different formats by Mr. Thompson. That's part of the public record. We've been accused of violating the non-dissemination order. Dr. Edelman's reputation has been impugned by what was stated about him repeatedly. Those questions are fair game. But having this hearing and allowing our expert to talk about this process, that's not the problem. The problem with the media happened a long time ago, and it started with the sharing of the affidavit far and wide.
I understand that. I'm pulled in 2 different directions right now because I'm trying to protect your client at the same time. So if we keep talking about this, what is not true, okay? I mean, I guess we can just say, well, it's not true on some of these questions. Maybe that helps to reduce bias. But if we don't make that clear, then it could increase bias. I think. I don't know. Tell me. Maybe.
Well,
I'll hear this from the expert.
I'm going to say it like this. Mr. Kohberger is my client, and his rights are of the utmost importance to me. Him being treated fair, his presumption of innocence, him having an impartial jury, those are important things to me, as is his right to counsel. I am not standing up here saying, let me tell you about this survey. Let me finish this survey to hurt him. I'm saying there is pervasive media coverage in this case. It's prejudicial media coverage. We've conducted a survey in Latah County. That survey is going to show bias and that you shouldn't have a trial in this county. What I'm trying to do is say, do you want me to give you information about another place where maybe the bias isn't so great, where maybe Mr. Kohberger can have a fair trial? I'm his advocate. I want to help him. I believe in his innocence. I'm not going to stand in this courtroom and do anything wrong to him at all. I need you to hear the information so you can make a decision, to have the surveys, to have the information when we come back here for change of venue and make a decision on all of the information. Right now, if we come in and do our change of venue, we're going to say you can't have this jury in Latah County, but I can't tell you a better place that will protect him better. And that's what I want to do.
Any response, Mr. Thompson?
We aren't here to argue about venue today. We aren't here to argue about what this particular survey with the loaded questions, fact-loaded questions, may have produced in Latah County residents. As we mentioned last week, the structure of those questions assumes that every person that is called has heard all of the media in this case. And we know that that just simply isn't true. So for those citizens in this county who have not heard all of the rumors, who have not been following the media, who haven't inspected the court record, who are essentially ignorant of facts in this case, well, that's just been jaundiced by the questions that were asked. They have now been force-fed facts, some of which are not true, some of which would not be offered in court, and in fact, probably wouldn't legally be admissible in court, to somebody who may never have heard them before. That's the state's concern about the way this thing is put together. And the arguments from the defense seem to be completely ignoring that point. That there are people out here who don't know all the things that they were being asked, and by asking the fact-specific questions, we were inoculating them with information that they didn't have before about this case that could affect their ability to sit as jurors. It's just simply irresponsible. It doesn't make sense.
This is one of the things that I was thinking about, is maybe we can inoculate by saying you can't rely on any of this information. It's not established by evidence. It's not been provided in court. But to just send a message out to be clear that these questions have nothing to do with guilt or innocence or even truth.
But that's not what was done, Judge.
I know. We have to fix this in some way.
Yes, sir.
That's what you said last time. And so I just want to help the public understand that this is not the trial.
Your Honor,
Yes.
at this rate, we may never get to trial. We know this isn't the trial. We brought Dr. Edelman to talk about the process, which will answer the state's concerns about this process. He hasn't even had a chance to tell you how this is constructed. He's the one that's the doctor of this kind of work. He's the one that's the professional. He's the one that knows how to do this. He's the one that spent his career understanding surveys and how to construct these. You need to hear from him. Going back and forth between what Bill thinks and what I think doesn't matter. What matters is you hearing from the expert to make a decision. He's here, he's ready to testify. We're 20 minutes into this hearing and he hasn't been allowed to take the stand yet. He came to inform the court about this process.
Well, there's no question I'm going to let him testify. I just wondered about what's in this. I haven't looked at this, but it's you're comfortable having this come out into the public?
Yes, after last week's hearing, absolutely.
Okay, and you looked at it, Mr. Thompson?
You have concerns,
Is
Judge.
it alarming?
Well, part of what's in there is a part of the survey study being published now, if this comes to the public without any comparison to anything else. And it's the product of these loaded questions. It takes us back to the fundamental issue of how this survey was conducted and the assumption that the people who were being called already knew all this stuff. And so it didn't hurt to specifically ask them, have you heard about such, the specific item? Well, if they hadn't heard about it before, they sure as heck have heard about it now. That's the core concern that led us to this in the first place. We don't dispute the defense doing a survey. I said that last week. Please do a survey, but don't go around screwing with the knowledge that prospective jurors have or may not have. That's our concern. And, Your Honor, when we parted ways last week, the court said, Ms. Taylor, talk with Mr. Edelman and see what the options are. Well, my understanding from the email I received day before yesterday is the survey cannot be changed. That was from Ms. Taylor reporting what Dr. Edelman said. I interpret that as they don't want to change it. Anything can be done, but that's where we're left. I would have been happy to engage in discussion with defense about maybe some middle ground, but the line has been drawn black and white. I am concerned about the specific things that relate to venue, partial survey results that are in this PowerPoint. I believe it is premature for them to come out now. The rest of it is fine. Let's bring it out so that you have whatever information you want. You can give it the weight that you decide. I just didn't want to let this willy-nilly come into the public record in a half-baked fashion.
I have lots of concerns. We're not left with this because I have to make a decision about several things.
Yes, sir.
And so in order for me to have the most informed decision, I need the information. So we're just going to go ahead. All right.
Thank you.
And you can show your slides, and if something is concerning, we can talk about it along with it. All right. So, are you ready to call your witness? I think you are.
I am. I'm ready to call Dr. Bryan Edelman.
Okay, Dr. Edelman, if you could please come forward, face the clerk, raise your right hand. There you go.
You solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, thank you, sir. If you could please take your seat there. And then once you're comfortable, please state your name and spell your last.
It's Bryan Edelman, BRYAN EDELMAN.
Thank you. Ms.
Thank you.
Taylor.
Good afternoon, Dr. Edelman.
Good afternoon.
What do you do for a living?
I work as a trial consultant, and also I do quite a bit of work as an expert witness in the field of pretrial publicity and change events.
Are those two separate roles?
Yes, they are.
What do you do when you're a trial consultant?
So as a trial consultant, you're an advocate for your client. You do mock trials, focus groups, to really try to develop a trial strategy, a trial story for your side, and cultivate that for the audience, the jury. We also do jury selection. I assist with writing voir dire questions, juror questionnaires, help ferret out bias during voir dire, recommend cause challenges and how we use peremptories, do post-trial interviews. I do jury-related research, present my findings at conferences, bar associations, law firms, and so on.
When you work as an expert in the field of change of venue, does that differ from your work as a trial consultant?
Absolutely.
How so?
Well, as I mentioned, as a trial consultant, you're retained to be an advocate. As an expert, you are retained to be an objective expert, which means I'm not advocating for either side. I do not advocate for the defense. I do not advocate for the prosecution. My role is to collect information using standard methods that have been widely accepted in the field, and then present the findings to the court so they can make a well-informed decision on whether or not any remedial measures are necessary. So there are times where my findings support what remedial measures, like a change of venue, and there are times they don't. And when they don't, I recommend against a change of venue. Whatever the data support is where I go.
I want to understand a little bit about your educational background that allows you to do that work.
Okay.
How were you educated?
I'm sorry.
How were you educated? What degree?
Starting in grammar school.
we can skip to college.
Yeah. So I have a bachelor's degree in psychology from Florida State University. From there, I attended the University of Nevada in Reno, where I studied social psychology. My particular interest was in the application of social psychology in the field of the legal arena. So I was really interested in juror decision-making, jury decision-making, group dynamics, how people process information and evidence, the impact on pretrial publicity. I helped run a program through the Department of State that brought in judges and attorneys to the United States, where they would travel around the country and meet with people in their field. So I worked with the National Judicial College in that regard as well. And then from there, when I finished my PhD, I got a Rotary Scholarship to study in the United Kingdom, where I got an LLM in International Humanitarian Law, which I do not use.
During the course of your career, have you been published?
I have. I've been published in this area of survey methodology. My research was on the death penalty, so I have a book published on the death penalty. I am the co-editor in California. There's something called the CEB, the Continuing Education of the Bar, and there's a criminal procedure book that comes out every year. It's kind of like the Bible for criminal procedure, and I'm a co-editor on the chapter on change of venue. I was also on the committee for the American Society of Trial Consultants that publishes professional guidelines for writing change of venue surveys. So I'm on that. And I've also done research on, one of the questions is always, well, why can't we just pick a jury in a high profile case? So I've done research on the use of the set aside question. So if people have been inundated with a lot of prejudicial media coverage, how do they respond to that set aside question? Do we see, for example, if somebody's been exposed to a lot of prejudicial coverage, you'd expect them to say, I cannot be fair and impartial, I know too much. And so we were looking at research on that as well. And then last thing I promise is, I've also done research on what's called minimization language. So when you ask people an open-ended question on a juror questionnaire or in voir dire in a high-profile case, this is the only standard question, what have you read, seen, or heard about this case? That's the open-ended question. And people minimize what they know. That's something Dr. Ed Bronson came up with because he had noticed it. And that's like using language such as, I only recall what was in the paper, or I just followed it. I just remember it was on the news. You don't really elicit a lot of information. It's minimized knowledge. So did research on that too.
That's been part of your research?
Yes.
When you work as an expert, if you're hired as an expert to work on a change of view issue, and I think you told us how your work is different than when you're a trial consultant. Can you tell me how you start in that role as an expert for change of venue?
Yeah. So first of all, I've been doing this for about 15 years, I'd say, as an expert witness on this area.
On change of venue
On change of
specifically? Okay. And to do with surveys, just to be clear?
Yes. From some it's surveys, other times it's post-conviction, once again. I've done it federal cases, state cases, multiple states, including Idaho. But the way I learned was from Dr. Ed Bronson, who was kind of the pioneer in the field. He worked on cases like the Oklahoma City bombing case and a host of other prominent ones, the Boston Marathon, a bunch of them. So he was kind of my mentor in this area. And there's a 3-stage process. So the first phase is collecting the media coverage. Because really the question is initially, is there extensive coverage and is there prejudicial coverage? So I collect the coverage and assess the nature of that coverage. Does it include inflammatory language? Does it include inadmissible or misinformation? Now, just because it's not true does not mean people don't see it. And it does not mean that they don't develop opinions based on that information. So it's very important. In fact, some of that stuff is the most prejudicial stuff that there can possibly be. For example, if there is a prior conviction and then the conviction's thrown out, well, that's pretty prejudicial for the new trial. Not admissible, but very prejudicial. So I'm looking for information like that. I'm looking for references to prior records. Maybe there are victim impact statements where people, victims' families may be suggesting what the outcome should be. That could be prejudicial. How did the community respond? Are there candlelight vigils? Are there, GoFundMe efforts going on? The status of the victim, is it focusing on that? So there's a gambit of things that we look at. Sometimes there's political elements that are important in high profile cases because it might be that a politician's involved. So it just depends on the case. So the first thing is assessing the nature of the publicity. Now, if there's not a lot of extensive pretrial publicity and it's not prejudicial, it stops there. And that's happened where there's coverage, but it's very superficial. It's very neutral. There's not a lot of detail. There's nothing particularly impactful. Maybe it's focused primarily on just the victim or something like that. However, there are other cases where there is extensive pretrial publicity, and then I would recommend phase 2, which is a community attitude survey. Because just because there's prejudicial coverage does not mean it had an impact on the jury pool. And that is the question that matters most. What impact has the prejudicial media coverage had on the jury pool? I don't really care if it's correct information, it came from social media, it came from the news. It had an impact on the jury pool. That's what matters, because they develop opinions and attitudes. And it doesn't make a difference if that fact is true or false. They still develop an opinion and an attitude about the defendant, about the evidence and perceptions of guilt. All of that is what I'm looking at. So I want to see if the media coverage has had an impact. And that's why we do a community attitude survey. And then depending on the results of the survey, there's not enough evidence there to suggest that anything is required. It could be remedial measures such as individual sequestered voir dire. Maybe that's appropriate in some cases, all the way to the extreme case where it might be a change of name.
I want to understand a little bit about the source of media you review to do your work. Can you tell me what you take a look at?
I always take a conservative.
Your Honor, I'm sorry, I need to object. This PowerPoint is being played for everybody with no foundation. It's not an exhibit. I think that's improper. I mean, I'm trying to listen to Dr. Edelman's testimony, and I keep seeing slides changing in front of me over here, and I don't think that's appropriate.
Well, you've seen the slides.
I have.
You looked
But
at it.
everybody else here hasn't.
What I'm seeing here, though, is just an explanation of how he goes about in surveys.
Understand that. That's what his testimony is. But we're getting this visual aid that there's no foundation for, Judge.
Well,
It just seems
I'm
highly unusual.
well, hold on. I'm viewing him as an expert.
Yes, sir.
Okay? He's explaining what he does. So I'm going
No
to,
problem with that. The PowerPoint's a problem. I don't have any problem with his testimony.
all right.
I'm sorry.
Yeah.
Frankly, I've never seen
No,
something like this occur.
That objection. I mean, this is not necessarily factual. It's just an example of how he got to where he got.
That's his testimony, but the PowerPoint is different, Judge. I don't know why we're seeing the PowerPoint when we have his testimony.
You want to respond to that?
I do,
Okay.
Judge. This is a courtroom demonstrative aid that helps to track the testimony of Dr. Edelman. I can hand him my computer and let him advance the screens if that makes a big difference in it. This just helps explain his testimony.
Judge, we don't have a jury here. Let's just proceed.
Thank you. Go ahead.
Dr. Edelman, we were talking about where you get your information.
We were talking about the way.
Where you get your information. What media do you look at? I think that's where it was.
Yes. So I take a conservative approach to how I do it. I look at newspapers in the local coverage right now. So I'm interested in papers that have primary circulation in the venue. Case like this has been reported in many other newspapers, but I wouldn't, for example, look at a newspaper published in Dallas, because I don't know if somebody in Latah County would be looking at a paper in Dallas. So I look at the local coverage. I try to look at like local television coverage to see what the community is likely exposed to.
While we're here, I want to ask you some questions about the non-dissemination order.
Okay.
That's been a hot topic, and you've heard some of it again today. Are you aware that there's a non-dissemination order in this case?
Yes.
How did you become aware of it?
Well, the first time I became aware of it was when I was reading the newspaper coverage, because that was one of the topics of media coverage, was discussing the non-dissemination order and media's efforts to have it changed. So I was able to read it and follow it in that media coverage. So that's the first time I saw it.
And in January, did you receive an email from my office with the non-dissemination order?
I believe I did.
And you looked at a hard copy again recently?
Yes.
All right. Does that non-dissemination order change how you did your work?
I'm sorry, can you know,
Does the existence of the non-dissemination order change how you did your work?
No, it did not.
Have you worked in cases where there's a non-dissemination order at other times?
Many times.
Was the sole source of the information that you use contained in the media?
Was it came from the media? Sorry. Yes. Everything I used was widely disseminated through the media. Widely disseminated.
Did you find out where the media got the information?
Yes.
Good afternoon, folks. My name is Bill Thompson. I'm the Latah County prosecutor. And it's sad to be here, but happy to be here at the same time.
You turn it up. I can't hear.
Kohberger,
Well, I'm gonna do my best to turn this up.
Yeah, you don't have to.
If I put the microphone up, is that better?
So, yeah, but Christie, you don't have to type out things that are recorded.
let me preface, there is a pending case now in court, and I and my office and the investigators have to live with the restrictions that our Supreme Court places on pretrial publicity. That said, I promise you we will share with you through the court process or otherwise whatever we are allowed to. I just appreciate your patience on that. The factual basis for the charges are summarized in what's called a probable cause affidavit that is on file with the court. According to the rules of the Idaho Supreme Court, that is sealed until Mr. Kohberger is physically back in Latah County and has been served with the Idaho arrest warrant. At that time, we expect that that affidavit will be available to you so you can share the true facts with all of your readers and your watchers and your listeners and all of the people who are interested and really need to know what's going on. So please have patience with us on that. We hope to get that to you as soon as we can.
In that clip, you heard reference to the probable cause affidavit.
Yes.
And did you hear reference to sharing it with all your readers and watchers?
Readers, watchers, and listeners, and anyone else who's interested.
Did your research tell you that the media took Mr. Thompson up on that offer to share this far and wide?
Yes.
Good afternoon, folks.
What did you see?
Basically, the media took that document and then published the highlights and key findings in that document and added editorial commentary to that information. So let's be clear, they didn't just read the affidavit. There's editorial, there's debate, there's discussion, there's spin, all of it in news stories. And these stories, for example, this one has over 200, I'm sorry, I can't see it. Do you have a copy of the,
I do. Your Honor, I have a printed copy of his PowerPoint. If it would help him refresh his memory. I just can't see it.
Sure, let's go ahead.
Okay, thank you. So example, this one is on a local television station. On YouTube alone, 130,000 views and 224 comments. So people discussing it. That's just one example of how this document was disseminated through the media in this county, just as Mr. Thompson suggested during his press conference.
And did you check another media source and see that it continued to be shared?
Yes, this is a second example. And you can see just from the heading, it says court records unsealed. And then they go through a timeline, including information from that affidavit, highlighting all the key findings about the car and other things that are widely reported and disseminated from that document, to lay to account, saturating the community with prejudicial details from that document, which was reported in the press conference to be truthful as well. 54,000 views, 176 comments on just one other video of a news clip on YouTube.
And based on your research, did the story or stories continue to be shared far and wide?
Yes.
Janelle Finch is joining.
Cases received massive media coverage, saturating this county with prejudicial pretrial rules.
How about to social media?
It was also spread through social media, and people have talked about it on social media.
And do you know if misinformation and rumors ended up as a result of this information shared right from the start?
Yes, and the reason I looked at this and knew it was because in the media coverage, they discussed the spreading of rumors on social media. For example, a professor who was accused by a psychic of being responsible for this. Other references to questioning the implication of people knew about the crime before it was reported to the police, and so on. So there's been quite a bit of discussion, spread of rumors, misinformation, factual information all over social media, which you'd expect in small communities such as this.
Did your review of all of this information tell you as a professional, as an expert in your field, that a survey was necessary in Bryan Kohberger's case?
Yes, based off of the media coverage that I reviewed, which was over 200 plus articles, and the television coverage, I thought it was appropriate to move forward to see what impact, if any, this coverage has had on the community.
What kind of survey did you think would be appropriate?
We always use random digit dial telephone surveys in these cases.
Before you tell me a little bit more about that, I want to understand the history of this kind of survey. Is this something that you just made up all on your own?
No.
Where does this come from?
So these surveys have been done for decades. The first one I recall that followed a similar design and focus on case-specific items was done in 1979. Constantini and King in 3 cases in Yolo County, California. This approach was done, Dr. Ed Bronson, who I mentioned, my mentor, had been using it for decades, 40 years or more. Other experts in the field do it. John Walker, in the American Taliban case, they used a similar approach that was published as well. Used in Skilling, Boston Marathon. I've used it in countless cases, so hundreds of times, I would say.
Is there research that supports this process?
There is. One of the things we're looking at, so when you think about the survey, is the structure and how we test validity. So there's 40 plus years of social science literature on the impact of media coverage on juror and jury decision making. And one of the things it tells us, for example, is knowledge. Or let's take a step back. People who regularly watch and listen to the news are more likely to know about the case. When I say know about the case, are more likely to have case-specific information from the media. So they test similar things like we did. Have you read, seen, or heard if ... And they assess how much knowledge does this person have? And then they correlate it with media consumption habits. And what you find is people that read the news regularly know more of these details than people who do not. And they find that the more information you have, the more likely you are to hold an opinion regarding a defendant's guilt or innocence. So those are some of the findings, and we craft the survey similar to the others because we want to test the validity of the survey. So if we know we should see these relationships, we should expect to see them in our survey. So we ask the same similar types of questions, and we look at those relationships to see if we see the same thing. That's one of the ways we test the validity of the survey.
Would this be considered a methodology in your field to do surveys in this certain format?
Yes, it's standard practice. We look at APOR, which is called the American Association of Public Opinion Research, American Society of Trial Consultants. They have professional code on how to conduct surveys, venue surveys. Those are the primary ones I look at. And again, I've taken course training during my program on how to craft surveys, how to write questions, all of that type of thing. I've done it hundreds of times, testified about it. So that's kind of the basis of how I craft this.
And I heard you mention standards and validity.
Mhm.
Why are there standards? Why does that matter?
I'm sorry, why are there standards?
Yes.
Well, one is you want to make sure, as we learn more about research in human behavior, we learn more about what you should and shouldn't do. So for example, there's something called social desirability. People want to create a positive impression of themselves. So when you ask questions, for example, can you be a fair juror? Well, we all want to be fair people, so you're more likely to get a socially desirable response. The initial step on that was all the way back into voting. In California, there was an election for governor, I think it's Davis or something like that, and all of the polling suggested he was going to win. He was African American, and he lost. And that was when they started looking at that, and they saw all these different impacts in terms of like race of the interviewer. All these things affect how people respond. People overestimate that they vote because you can look at voting records and it's inflated. People overestimate they have a library card and a million other things. So those are things like we look at when we craft the survey. We don't want to have social questions that lead to socially desirable responses, order effects, a host of other things.
In your survey, it looks like you have sections designed in your survey.
Mhm.
Sorry, can you hear me? Okay.
Better with the microphone.
Okay, I'll try to stand closer over here. I want to understand this section, these sections. Why do you have sections in this survey?
Sections?
Yes.
Well, one is you don't want things to be jumping back and forth all over the place because it's harder to take a survey like that. You'll have more people drop off, confusion, potential order effects. So we try to organize the survey into sections. So all the key questions on one topic are together, and then the next section changes topics, so it's easy to follow.
What is the purpose of section 3, case awareness and prejudgment? Why is that in there?
So that's the meat of the survey. That's the most important section. So case awareness measures initially case recognition. We craft a recognition question based off of the media coverage. What are the things widely reported that are not overly prejudicial because you don't want to create an order that would stimulate a memory of, yes, I remember that case. So if widely reported A, B, and C facts that you read the coverage and you see this was mentioned 100 times, that's a widely reported fact. So we create case recognition question. Now, if somebody says, yes, I remember that case, I have read, seen, or heard about it, they're asked a prejudgment question next, guilt or innocence question. Then they're asked open-ended questions and then those case-specific items. Now, let's say someone does not remember the case based on that case recognition question. We give them one more fact to see if it'll stimulate a memory. Something neutral that might stimulate a memory. You usually get 1 to 2% more that recall the case from that. If that person recognizes the case from there, they are also asked that prejudgment question and they continue. If they do not recognize the case, they skip the rest of the survey and they're asked demographic questions about media consumption habits and demographics. The next step of the survey after the prejudgment question is an open-ended question. What have you read, seen, or heard about the case? There might be a few others we add based off of these things we might find in the media coverage. And then they continue on to those case-specific items that we've been talking about. Have you read, seen, or heard if so and so?
I want to make sure I understand this and that this is clear for everybody. Those 9 questions that have been the problem last week and this week, if you have somebody who says, no, I don't know that case, do you ask them those 9 questions?
No, they skip to the demographic questions.
Tell me, what are the demographic questions, just to be sure?
If somebody doesn't recognize the case, they immediately go to questions, for example, how often do you read the newspaper? Every day, several times a week, rarely, never, something like that. Then they're asked how often they follow the local news, and then they'll ask a few demographic questions like age, gender, race, ethnicity.
So if somebody doesn't remember the case, you don't infuse information or do any of the things that were brought out last week.
No.
I have on the screen in front of me some of the read, seen, or heard questions.
Yes.
What are these? You don't have to read them all, just tell me what they are.
These are 9 items, which we always use. Have you read, seen, or heard if? And these are items taken from the media coverage that were widely reported. And let me be clear, widely reported hundreds and thousands of times, and potentially prejudicial items, because neutral run-of-the-mill media coverage is often not grounds for a change of venue. So if somebody knew there were 4 victims, that's not particularly prejudicial, is it? That's a pretty benign fact. But if somebody knows, for example, about a prior conviction that's not admissible, that's very prejudicial. And it might be correlated with prejudgment. And I would like to know that, because if it's widely prejudicial and everybody knows about it, and it's correlated with prejudgment, that would likely have an impact on my recommendations, because that's the type of pretrial publicity that has been recognized by the Supreme Court, I'm sure the state court here, that is most concerning.
So these kinds of questions, these case-specific questions, you do this in all the surveys that you do.
Yes.
And in this case, these 9 questions came straight out of the media.
Absolutely. And again, widely reported throughout the media, thousands of times.
Now, just to be clear, you gave an example of information that might be widely reported that's highly prejudicial that you would use in a survey. You haven't talked about Bryan Kohberger's survey yet, have you?
What do
You haven't told us the 9 questions.
I have not.
Okay. And we'll get there, but I want to talk about a little bit more about the history of this survey. You told us it had been used for decades. And I think you told us a little bit about some of the other really high profile cases where this survey format, the survey method that's been widely accepted was used. Are some of these cases your cases that you've done these surveys in on this list?
Yes, I used these types of questions in the George Floyd case for Alexander King, who was one of the defendants. There was also a gag order or non-dissemination order in that case. The Parkland shooting case in Florida, there was a non-dissemination order in that case. Used there as well. Used it in the Pittsburgh synagogue shooting case in Pittsburgh. State of Idaho v. Jonathan Renfro, which was here. State of Idaho v. Gilberto Rodriguez, also used it there. And many others. I've used it 100 times. Dr. Bronson used it more than me because he was doing it even longer than I have. Other experts in the field do it. This is the standard practice.
Standard in your field.
Yes.
And are these surveys, doing a survey like this, is this just criminal defendants that ask you to do these surveys or that have any interest in doing these surveys, or is it other people too?
Other people use the same process as well, including the prosecution and the government.
I think you provided an example in your PowerPoint of the government using this survey process in
Yes.
a case that you worked on.
Yes, this was the Jason Van Dyke case in Chicago. He had been charged with shooting and killing Laquan McDonald. It was like 17 shots was like the famous saying. It was a very significant case, interracial crime, widely reported on. And the government also did their own survey to see if there was any potential bias and followed the same exact process and used case-specific media items. And once again, there was a non-dissemination order in that case as well.
Earlier, you talked a little bit about validity being one of the standards.
Yes,
Tell me how you measure validity in one of these surveys.
sure. So this is from the professional code from the American Society of Trial Consultants. As I mentioned, we want to look at things like consistency. So we want to, for example, the research tells us the more case or media items you know, you develop knowledge. And the more you know, the more likely you are to exhibit bias. So I want to test that in the survey. That's one of the reasons why I include those case-specific items. I also want to compare what people or that item to prejudgment. So the more people know, are they more likely to prejudge? How about case-specific media items? Is there specific prejudicial items in the media that are particularly concerning? Maybe I'm going to go back to my prior conviction example. If there was a conviction, so I've had this happen in the case, and then years later, that conviction was thrown out and there's a new trial. Well, that's extremely prejudicial if people know about the prior jury verdict. So I want to know, what percentage of people know that detail? And is that related to prejudgment? And most importantly, when you ask the question, have you read, seen, or heard about the case? The open-ended question, do people report it? Because if they don't, and they do know it, well, that's very concerning. And that's the type of problem we run into in voir dire.
Sounds like that's one of the reasons you have case-specific questions in there.
That's one of the reasons, absolutely.
You heard talk last week, and then you've heard it again today about, can't you just change this survey and take those case-specific questions out and then do the survey? Can you do that?
I would not do that, no.
Can you explain why not?
Because this is based off of 15 years of doing this. I know for certain, and there's research on it as well, that when you ask people an open-ended question, what have you read, seen, or heard about the case? They have a difficult time recalling everything from memory. That's a recall question. The cognitive effort required to recall everything from memory that you know is very challenging versus recognition, which is a much lower cognitive load. Have you read, seen, or heard if? Oh, now I can search my memory. Yes, I know that fact. If I asked you, tell me everything you know about the movie Star Wars, you would tell me a whole bunch of interesting things about Chewbacca and Ewoks and maybe a bunch of other stuff. But I am very confident that you would miss things. You would not tell me every single detail from memory you know about that movie. And then I would ask you something like, did you know that Darth Vader was Luke Skywalker's father? And you'd probably say, yeah, of course, I knew that. But you didn't mention it in the recall question. There's a mountain of research on this. Usually what they do is they have people read like a paragraph or a story, and they ask them, write down everything you recall from what you just read. And then they do a different type of quiz. Did you read that the truck was red? Did you read that there was an ambulance? Oh yeah, of course. And they check that too. And what it shows is recognition rates, the ability to recall information when asked a closed-ended question, is much higher than when you ask an open-ended question. So getting back to your comment or question, if I only ask, what do you know about this case? I know for a fact you'll get things like, well, I remember when it happened. There were 4 victims. There was a knife. I remember there's a delay. I just saw it in the media. Those are the things that people say. They've said it in this survey. They've said it in 100 surveys I've done prior. They've said it in voir dire when I look at transcripts. That's what you see. But when you ask those closed-ended questions, you discover that they know quite a bit more. And that's what I'm trying to look at. I need to know, what do people actually know? And is there information, prejudicial details that they don't mention that they do know when you ask the open-ended question?
And those details, the closed questions, the have you read, seen, or heard questions, are they important to determine if there's bias, that media coverage has created a prejudicial effect, and that there's bias?
Absolutely. If 80% of people are able to recognize a prejudicial detail, and I keep making up because I don't want to upset anyone here, like a prior conviction, if 80% know that detail, but only 3% mention it in the question, what have you read, seen, or heard about the case? That's a major problem. I need to know that because it's an extremely prejudicial fact. Things spread on social media, whether they're true or not, they still impact the jury. Very prejudicial. I need to know if they know that. And I know for a fact in this case that, for example, I'm not going to mention the detail, but for one of them, only 3% of people in this survey mentioned the detail when asked, what have you read, seen, or heard about this case? It was something spread on social media. But when you asked, have you read, seen, or heard of X, Y, and Z, 45% knew that fact. And that fact happened to be significantly related to prejudgment. People who knew it, over 80% of them think the defendant is guilty, compared to 57% who don't know the detail. So those are important findings. If I don't include those questions, I can't do any of those analyses. It makes it look like there's not that much of a problem here. People don't seem to know anything. They just say they remember reading it in the paper. I guess we don't have to move the case because they don't seem to know much. And that is misleading, inaccurate, and I would not do that.
Have you had a unique opportunity to kind of actually watch this in real time to see how it works?
I have.
Can you tell us about that?
Yeah.
How did you get this unique opportunity first?
So I worked on a case that was called John Fight. This was a Catholic priest in Hidalgo County in Texas who had been charged with murdering a beauty queen. Now, the crime had happened in like the 1950s, and the trial happened in like 2018 or something like that. So all the witnesses were gone, and the defendant was obviously much older. But it was a case that was just weaved into the fabric of the community. It was so shocking. And during the hearing, after doing a survey, one of the things we did is we brought in community residents and did like a mock voir dire to prove this point, to demonstrate. And there was a bunch of things in that case that were particularly prejudicial. So we asked people, tell us what you've read, seen, or heard about the case. And they would tell us, oh, in college, I learned about this case. I know A, B, and C. And we say, is that everything you remember? And they said, for example, here, I believe so. That's what this person said. Search their memory. Let's see. I believe so. That's it. And then we asked those case-specific questions that you clearly could never ask in voir dire because you'd be poisoning the well. And we asked, for example, did you know that John Fight gave a confession to a priest, confessed to the crime? Oh, yeah, I knew that. And once she said that, it stimulated her memory. Actually, he confessed twice. So now she knows that. The fact that she did not mention in the open-ended question, extremely prejudicial. The Supreme Court has recognized confessions to be very prejudicial for Doe v. Louisiana and a bunch of others. And she knows that. And then we ask, kind of again, is that everything you know? And she says yes. And then we give her another one. Did you know that he was involved in another case? He had actually been charged with attacking a woman in a different church. Oh, yeah. Yes, I do remember that. Once again, she knows a detail that she didn't mention. And we're saying, okay, and you didn't say that a few minutes ago, did you? No, that's the second one. And then we asked, having refreshed your memory, are there any other facts that you have read, seen, or heard that you haven't told the court? She's, I don't believe so. So it seems like that's all she knows. Then we try it again, and we mentioned that he had been transferred to another monastery. The Catholic Church was moving him around. And she knows that too. Oh, yeah, I did that. And we tried again. Did you know that local law enforcement were participating in a cover-up? That was part of the story. Yeah, she knows that too. So this was an example of the difference between asking the open-ended question that you can ask in voir dire, what do you know about this case? What have you heard about this case? And you get an answer. Sometimes people say, I just recall when it happened. Sometimes you get more detail. But when you start asking those closed-ended questions, you uncover that actually they know quite a bit more. And that is the key point in a high-profile case. In the general case, it doesn't matter because there's no case-specific information. What we know is that specific attitudes predict behavior much more than general attitudes. So in a community like this, it's been saturated with media coverage that's prejudicial. We want to know what case-specific details they know, because that goes to bias, and are we able to ferret out that bias in jury selection? And that's why we include those questions in our survey.
I want to talk about Bryan Kohberger's case for just a minute.
Your Honor, again, I'm going to register the objection. This is going to deal with the actual issue of change of venue. It's premature. The state has not been afforded the opportunity to analyze, much less respond to it. So to the extent that the court wishes to allow this to continue, I just simply ask you to give it that reduced amount of weight, because the state is not in a position to respond to any of this.
Okay, thank you. But you'll have an opportunity to respond to any of this where I make a decision.
Not today, Judge. I'm sorry.
Hold on.
Yes, sir.
I'm not going to make a decision today.
Yes, sir.
I'm getting information,
Yes, sir.
and then I'm going to consider what you're going to provide, and then I'm going to make a decision.
My point again, Your Honor, is this goes to the issue of a change of venue, not whether or not the non-disclosure order was violated and what we should do about that. Two separate issues. The state is not prepared and will not be prepared to address a change of venue issue until an appropriate motion with supporting documentation and evidence provided. And we have a chance to respond to that, which I understand we'll be doing between now and sometime next month.
Exactly.
Thank you.
Go ahead.
Thank you. Dr. Edelman, you haven't finished analyzing the data in Mr. Kohberger's case, have you?
No, the only thing I looked at was supposed to be on the question at hand, which is about these case-specific items, why they're in the survey, and which goes to whether we can continue the survey without them. That's the only thing I looked at, was addressing that specific question.
I'm not going to ask you what your opinion on change of venue is today.
I don't have one. Well, I do, but I'm not done analyzing the data.
Senate, I want you to be informed before we get there. So I do want to talk, though, about Bryan Kohberger's case and if you've been able to determine if the survey was valid.
Yes, absolutely.
And how did you determine that the survey is valid?
Well, one of the things, as I mentioned, is looking at the social science research and do we find similar findings? And we did. So we also look, for example, do we have like acquiescence bias? What that means is people are just saying yes to everything. So on those case-specific media items, one of the things you do is you include items that didn't receive as much media attention. That way, you want to make sure, and what you expect to see are items that get a lot of media attention, everybody knows about. So you see really high recognition rates, 80%, 90%, 60%. And then the items that didn't get as much attention, they're lower, 40% or less. So we want to see if there's variance across the questions, and we see that as well.
Does it help to do the recall questions and the recognition questions to understand whether you have a valid survey? Is that what you're telling me?
Yeah, well, as I mentioned, those are the case-specific questions. Yeah, those media items. So we test validity by, are those correlated with prejudgment? Are they correlated with media consumption? So people who read more of the media, do they know more of these details than people who don't? The more details you know, are you more likely to be biased? All that stuff. But also, again, like I said, is you want to check to make sure there's variance across those media items, because you want to make sure people aren't just saying yes to everything.
You talked early on about how if somebody doesn't recognize the case, you stop and you don't ask these case-specific media generated items in your question.
Correct. And remember, these media items also come after the open-ended, what have you read, seen, or heard about the case?
Do you know how many people did not know about Bryan Kohberger's case in this survey? The percentage?
I believe it was like 3 to 4%.
And so that percentage of people didn't get the case-specific questions. Is that fair?
The people who did not know about the case, the very few, did not get the case-specific questions.
I want to talk about the open-ended questions and then the have you read, seen, or heard questions. On the open-ended questions, when you say, what do you know about this case? Tell me everything. Do you know about how many things people remember?
Yes, so one of the things we do is we read everyone and we track how many details they mentioned. And then we compare them, what did they say, to how many case-specific items they later recognized. So for example, if somebody said, I know 4 people were killed and they found the guy, I would identify like 2 facts, 2 details, for example. And then I would look at those case-specific items later and how many of those items did he mention in the open? And that scenario would be 0. But if he knew 6 of them, that would tell me that he knew 6 details that he failed to recognize. Versus somebody might have known all those details and mentioned all of them in their open. Then it would be 0. They reported everything they knew, and they mentioned later on that they knew those items. So I look at that.
You're checking what they say they know in the general open question, and then see if they hit some of the specific questions, and then measuring how many more they actually know when you get to the have you read, seen, or heard question.
And then I compare. And that kind of goes to my John Fight story. I'm looking to see if that is a problem.
What did you find in this case?
I found that 96% of survey respondents knew at least one additional media item that they failed to mention in the open-ended question. On average, people reported 1.6 details when asked the question, what have you read, seen, or heard about the case? However, on average, they later recognized 6 out of the 9 media items, and I believe it's something like 72% knew, I want to say 5 or more.
Now, in this situation, did you find out people had a lot of knowledge that wasn't the specific case-related question? They would rattle off, I know these things, several things.
Yeah, so what I found was, on average, people knew at 4.9 additional items that they failed to mention in the open. What does that mean? That means they knew approximately 5 of the media items that I tested later that they did not mention in the open-ended. 5 on average out of 9 they knew, although they didn't mention them. And these are examples. So somebody wrote just what has been on the TV and the papers. That's the common thing you get when you only ask the open-ended question. But that person knew all 9 of the media items we tested. Someone else mentioned the detail. The kids were murdered and they tracked them down. Well, he actually knows 6 out of the 9 media items that we tested. Nothing lately knows 7 out of the 9 media items tested. And it goes on and on. That is a very common finding. I find it in almost every survey I do. Between 92 and 96% is the norm. What I see in terms of knowing more detail than they report. And it usually, interestingly, the average is usually around 3 extra media items that they failed to mention. In this case, it was 4.9, so it's higher.
Do you have a way within the survey to correlate prejudicial coverage or bias for guilt with the amount of specific details recognized?
Yes, because I asked those case-specific questions. If I didn't, I would not be able to. Because as you saw, people say things like, haven't seen anything lately. Well, that doesn't really do much for me. I can't analyze that. I can't do anything with that. I don't ask those case-specific items. I can't test the validity of the survey. I can't test to see how case-specific knowledge impacts prejudgment. I can't test to see if there's one particular item that's highly prejudicial that we should be worried about, that should, that's inadmissible. What percentage knows that detail? All of those things are required to do this correctly.
And how do you know that there's prejudgment in a case? What questions do you ask, and when do you ask them to know that there's prejudgment or bias in a case?
Well, after the case recognition question, they're asked, based off of what you've read, seen, or heard about this case, you believe the defendant's guilty of whatever the crime is, and it's on a scale of like definitely guilty to definitely not guilty. So that's a prejudgment question. I have a second follow-up question, which was actually developed from a judge that I thought was really effective. And the question was, would the defendant have a difficult time convincing you that he's not guilty? So it's a presumption of guilt as opposed to a presumption of innocence. This was in Tennessee. It was a high-profile case, and similarly, people would report a lot of detail, and then they'd say, "I think he's guilty," and then that's what, can you be fair and impartial? And they go, "Yeah, I think I could be fair. I can try. I think I could do it." And then the court would ask, "Well, would the defendant have a difficult time convincing you that he's not guilty?" And they'd say, "Oh yeah, definitely. It could be hard to change my mind." So I use that question because I thought it was really effective, and it happens to correlate much better than the set-aside question with prejudgment and a host of other things.
So do you ask those questions before you say, have you read, seen, or heard these particular?
Absolutely. If you didn't, you'd be creating order. So you have to do that.
Will you say that again? You'd be creating what?
Order effects. If I put in like a recognition question, some detail that's extraordinarily prejudicial, I'll go back to my prior conviction thing for the same crime. And then you say, "Oh, do you think he's guilty?" Well, you just told me a jury convicted him. Of course I think he's guilty. So if you included all those 9 items, and then you ask somebody, "Do you think he's guilty?" You just gave them all this information that's prejudicial. So yes, that would be an order. So we would never do that.
So you ask them well ahead of case-specific questions. They have to recognize the case. They have to agree, I know of this case. And then you ask if they already have an idea of what they think of whether Mr. Kohberger is guilty or not in our case.
Correct.
And then you have the case recognition, and you can measure the bias or the prejudicial effect of the media with the incidence of those questions.
What I look at is the prejudgment question, right? That's on a scale, so Likert scale. And then I can look at things like, is a relationship between the number of details somebody knows and the strength of opinion? Definitely guilty. For example, if you know a lot of detail. I can look at case-specific items, media items. If you knew about X, is that correlated with prejudgment or bias? Is there something that, and so on and on. So that's how we look at the relationship between prejudgment and these different factors.
Were you able to determine if case knowledge was impacting bias in Bryan Kohberger's case?
Yes. So because we asked these questions, what we found is that one, like I said, very high recognition rate. So 79% of respondents knew at least 5 of these items. So the idea that we're undermining his due process rights, everybody knows all this stuff. It's very high rates. 82% of respondents who recognized 7 of these items or more reported that he's guilty, compared to if they only knew 2 or fewer, only 29% thought he was guilty. And the average was 6.2. So the average number of these details people already know, 6.2.
Given specific case-related bits of information, these 9 have you read, seen, or heard questions, does recognizing one of those questions, if that's oh yeah, I know that one, does that change the incidence of bias, or does that relate to I've already prejudged this case?
It does. And what's really interesting is kind of going back to the open-ended question. So again, I won't mention the detail, but there's one that was widely reported. It's in that affidavit. And 81% of survey respondents knew that specific detail. 81% when we asked, what have you read, seen, or heard about this case? However, on the previous question, what have you read, seen, or heard about this case, the open-ended, only 8% reported it. 8% report it when you ask the open-ended question. 81% actually know the detail when you ask a recognition question. That's significant, and I can only do that analysis because we asked those questions. And 72% of people who knew that detail reported that he is guilty, compared to just 47% who don't know the detail. So that's the kind of analysis we look at. What do these case-specific items look like? If you know this media item, is it correlated with guilt? What percentage of people know that media item? How many people mention it in the open? Is it consistent, or is it perfect overlap, or nobody talks about it, but they all know it? In another one, only 3% mentioned a specific detail that was on social media, widely reported in the news, not factually accurate, a misrepresentation of the truth. 45% knew it in the survey. Only 3% reported it in the open-ended comment. And it was extraordinarily prejudicial, where if you did know it, 81% of survey respondents, if they knew that detail, indicated that the defendant was guilty. 81%, half the sample knew about it, but only 3% mentioned it when I asked the open-ended question. So again, if I didn't ask those questions, and the only thing I asked was the open-ended question, it would appear that people don't know a lot of prejudicial detail because they don't mention the detail when you ask that question. And that is, from my experience, doing post-conviction work, reading voir dire transcripts, coding transcripts, doing hundreds of jury selections, being involved in these cases, coding jury questionnaires. This is the phenomenon that we see all the time. It's nothing new. And the only way to look at it is by doing the surveys.
Before I ask the question about courts relying on surveys to make decisions, using these surveys to make decisions to change venue, when you talk about things that are in the media that aren't true or might not come in, we've heard a lot about that today. Are you telling me that that's still going to be in my courtroom? Things that aren't true, that don't get brought out in trial, those are still going to be in the jurors' minds?
Absolutely. And again, there's social science research on this, looking at the impact of inadmissible content, the effectiveness of judicial instructions, and how it impacts jury decision-making. Just because you say it's not evidence doesn't mean it's not prejudicial. Just like if I know it, it impacts how I view the defendant. It serves as a filter through how I process information. I might expect to hear that information when I can assume that I will, so it has an impact. One interesting study looked at jurors' ability or participants' ability to recall the source of information. And what they found is after a few days after a trial, people couldn't recall what information they had learned from the media and what information they recalled and learned from the trial. So they assumed stuff in the media came out in trial. The idea that I can cognitively say, okay, I know this prejudicial detail, and I'm going to put it in a box in my mind and never think about it and process everything, and it's never going to affect me. It's just, there's nothing to support that. It's kind of in our everyday lives. That's what our brains like. Think about what's going on today with Trump and Biden and all that. Everybody has strong opinions. The idea that, oh, yeah, well, it's not legitimate or that fact is wrong, it's misinformation, so it won't affect me. There's nothing to support that. There's even research that shows you have people, they read a passage, that they write something supporting a position that was in the passage, and then you tell them that information is not true. It's called belief perseverance or belief persistence. And what they find is even when you tell them that fact is not true, they still have a difficult time not believing it, and it still impacts their views. They still defend it, even then. So there's a host of research on this. The idea that we should only test things that are factually accurate and assume that the other stuff isn't prejudicial is just ridiculous.
So a massive amount of prejudicial media coverage is a factor that has to be considered in a case with this kind of coverage. Is that right?
Yes.
I want to know, though, from your experience, have you done a survey like this that contained these 9 case-specific questions where a judge decided to change venue?
Yes.
Will you tell us about that?
Yes. So in Nichols, there was a case in Washington, and this is kind of what I was referring to. So it was a defendant who had been convicted in 2012 for murder, Grant County, Washington. Later, it was a high-profile case, and then later the conviction was thrown out. It had something to do with jury instructions or something like that, and there was going to be a new trial. And quite a bit of time had gone by, like a decade. So we did a survey because that fact, knowing that detail, would be highly prejudicial. So what we found was 42% of survey respondents had read, seen, or heard about the prior conviction when we asked that case-specific media item. However, when we asked the open-ended question, what have you read, seen, or heard about the case? Only 12% mentioned it. So 12% mentioned it when you ask the open-ended question you use in voir dire, but over 42% knew about it. Now, you could never ask a juror, well, did you know a jury convicted him of murder if you didn't mention it because you're poisoning the well? And the court agreed and was worried about the effectiveness of voir dire as a remedy in that situation and granted a change of venue.
Have you had the opportunity to pay attention to any prejudicial media coverage since the hearing last week?
I have.
What is that coverage?
Well, it created a misrepresentation, false narrative that we, myself specifically, had done something wrong to poison the well, taint the jury pool, and using language like that. That became part of the narrative. I saw it on Reddit, on social media, in the news, that once again, going into this idea of what the story was, that the defense had done something wrong, debate about whether it was part of their tactic to delay, get him off on a technicality, and so on. And again, what I did, just want to be clear, is the standard practice in the industry, done hundreds of times in high-profile cases throughout this country. There's nothing I did to contaminate the jury pool. Everything I included was widely disseminated by the media in this county hundreds of times, if not more. And most of it came directly from an affidavit that the government released in a press conference and encouraged everyone to report.
Did I tell you what questions to ask?
You did not.
Would you take my advice if I told you what questions to ask?
I would not. And I'll tell you why, is as I mentioned, my role is to be an objective expert to provide the court with information so the court can make a decision on if any remedial measures are necessary. I don't care what questions you want in the survey, and I don't care what questions the government wants in the survey. What I want to do is conduct a valid survey that's objective, reliable, and provides meaningful information that can be used by the court.
Do you believe comparative surveys in other counties would provide the court with more information about what to do when we get to change a venue hearing?
I do.
Why?
Because this case has received a lot of media attention across the state. It's a national case. And depending on what the results are of the survey, I'm assuming if we find that there's grounds for a change of venue here, if that's a recommendation, the response will be, well, there's nowhere else to move it. Everybody's been cut saturated with pretrial publicity, so there's no need to change it. The point of the comparison survey is to address that question. Is there anywhere in the state where you could live it? Maybe there's not. I don't know. But that's the only way to find out. And you have to conduct the survey in the same manner. I don't know if I just ask people what they know about the case and you get general, I just recall when it happened, but you have the same guilt rate. Do they know inadmissible details? Do they know about things from that affidavit? Do they have a lot of case specific knowledge, or is it just a general awareness of the case? Did they drive by the house where the crime occurred? All these things that make this county unique that you want to test for in other communities. So it's not just a question of general awareness. I need to know what case specific information they have, what misinformation they have, what media items they've been exposed to. Do they have as much case detail and knowledge as they do here? All of those things. So that's why I would suggest it's important. Without that, the only thing I can do would be to collect the media coverage and assess, for example, like, are there fewer articles published in Bonneville County or Ada County compared to here? That's all we have. I wouldn't conduct a survey that I know is going to lead to misleading information. I'm not going to do that.
To change the survey, would that go against the methodology that you use?
Yes, if I change the survey and I don't conclude those items, I can't test. Well, do people know a lot of case-specific information that was widely reported? Are those specific items related to bias? Which items do they know? Do they know the ones that were all over social media or not? Like, that's the whole point of asking those questions. What you'll get is, well, I don't know much, but I saw it when it first happened. I remember reading about it a while ago, but haven't seen anything lately. I know the defendant was, arrested or whatever, or things like, oh, I followed it closely. Okay, great, I followed it closely. Does that mean they know a lot? I don't know. I can't assess just from someone said, I read the news or I followed it quite a bit. That doesn't tell you anything. That's not meaningful information. So yes, we need to conduct it in a safe fashion.
Last week, your professionalism, your work, your reputation was impugned.
I believe it was, yes.
If you're allowed, if the court says, okay, go ahead and finish these surveys, I want comparative county information, are you willing to still work with us?
If we do it correctly, if the idea is we want you to conduct a leading bias survey to get results that we want, then no, I'm not going to do something that undermines my credibility, my objectivity, or do it in any way that's not consistent with the procedures and standards that have been used.
Thank you. I don't have any other questions, Dr. Edelman, but the same, right?
Johnson,
Thank you, Mike. Maybe we'll start going backwards here, or from the back to the front topic. I'm sorry if you're feeling hurt about us raising this issue. I see you were almost breaking down a few minutes ago when you were talking about slide number 33, slide number 31. That's not the intent, and it's certainly, I'm surprised to see that reaction from an experienced expert such as yourself. So I apologize for that.
I accept your apology, but the idea of after working really hard 15 years to develop a credible reputation and being told, watching on a Zoom, that I am tainting the jury pool and poisoning the jury pool and contaminating the jury pool by doing what's required and standard, I'm not crying. I'm angry. Okay. And yes, it doesn't matter.
And please go ahead and be as angry as you like as you continue your work with the defense in this case. It is a fact, though, that you don't know of the 400 citizens that were questioned on this survey. You don't know which ones of them did not already previously know any of the fact-specific representations in your questions. Isn't that true?
I do know because they answered yes or no to the question.
No. Oh, well, okay, before you asked the question, you didn't know that. Isn't that correct?
That's correct.
And so somebody who hadn't heard the representation in that one slide that you acknowledged was false. Let's see. You acknowledged false that Mr. Kohberger allegedly stalked one of the victims. That's false. You know that to be false.
Which one?
That Mr. Kohberger allegedly stalked one of the victims.
Yes, I was trying not to say that because.
But you knew that was false.
I did.
Yes. And so you have now, for anybody who had never heard that before, that question is now planted into them, unqualified representation that Mr. Kohberger stalked one of the witnesses, and that's false.
That's false. Yes.
Yes. Okay. Thank you. Thank you.
Okay. All right.
And just to follow up on that, early on in your testimony, you testified, I want to make sure that we heard this correctly, that inadmissible or false information can be the most prejudicial information.
It can be.
Yes. And your surveyors put that false information into the minds of people who were asked that question who may not have previously heard it. Correct.
Correct. Relative
Thank
to
you.
the media.
Thank you.
It's mentioned it hundreds and thousands of times.
And just make sure we're clear too, around the same time in your testimony, I believe you testified that you don't care if the information that you put in your specific questions to the people being surveyed is correct. That you said that, didn't you?
Right. I don't know what you mean by correct.
True or false?
I care about whether or not it's proliferated by the media.
You don't care if it's true.
No, I don't. I
No.
don't care about is it prejudicial.
So it's okay to taint people who had never heard that information before for the end result of identifying others who have and might have bias. Is that a fair statement?
I'm gonna
No,
object to the
it's not.
questions. He's
He can answer the question.
badgering.
Wait.
Let me finish
Hold on.
my objection.
Yeah, there's an objection.
He's badgering the witness. He's misstating his testimony, and I object.
The witness testified he didn't care if the information was correct, Judge.
Yeah, overruled. So,
May I?
so just
No, that's okay.
one person can talk at a time. And, let's take down the tone a little bit.
Yes, sir. Okay, just so we're clear, the questions, fact-specific questions were propounded to people who were taking the survey. Did not, after asking the question even, qualify the false facts as saying this may or may not be true, or this is actually a false fact. The survey didn't tell them that what they might have heard was false.
First of all, I don't call them facts because they're media items. And then second of all, that would be ridiculous. And no, I wouldn't do that in a survey. Are you suggesting I follow up? Have you read, seen, or heard if he stalked? But oh, by the way, if you know that, let me tell you, it's not true.
Exactly. That's exactly what I'm suggesting, because isn't that exactly what happens in the voir dire process?
No.
Absolutely it does.
Your Honor, I'm gonna object, argumentative.
Okay, yeah, you don't get to testify exactly about that, so I'll sustain you.
Dr. Ellman, have you participated as an attorney in voir dire in Idaho under Idaho laws?
Have I what?
Have you participated as an attorney in voir dire, conducted voir dire in a criminal case in Idaho?
No, I haven't.
And just to be clear, because in two places, at the beginning and at the end of your testimony and your PowerPoint, this PowerPoint, you created that as Ms. Taylor. So you adopt what the contents of the PowerPoint speaks.
Yes.
Okay, thank you. Just to be clear, not every fact-specific question that your surveyors asked came directly from the probable cause affidavit. Isn't that true?
Well, to be clear, they're not facts, they're media items.
They're representations of
Your Honor,
fact
I'm gonna object.
in the PC
And
affidavit.
ask,
Hold on.
I'm objecting and ask that he allow Dr. Edelman to complete his answer before he jumps back in.
They're simple yes or no questions.
What was your question?
Oh, yeah. Let's just say, one at a time, okay? Listen to him answer, and we'll be through at some point.
Thank you. So, Dr. Edelman, isn't it true that there are among the 9 fact-specific questions, that's my characterization of the 9 questions, we know which ones we're talking about. Not all of the representations in those questions came from the probable cause affidavit. Isn't that true?
That is true.
And are you aware that under Idaho law, probable cause affidavits in criminal cases become open to the public by operation of court rule once person is arrested and appears in court?
I'm sure that's true. I'm just not used to having press conferences to tell the media to disseminate the information far and wide.
Oh, so let's talk about that. That press conference was made prior to Mr. Kohberger's appearance, prior to the release of the affidavit, and the press conference only referred the media to what would be part of the official court record. Isn't that true?
I don't know. All I heard was this is going to be released. I encourage you to tell your listeners and viewers and anybody who's interested in the truth.
By going to the court record and looking at the probable cause affidavit. Isn't that true?
I recall you saying, I want you to go to the court record and look at the probable cause affidavit. And what it did was
You're splitting hairs and meters now, doctor. That's fine. I don't have any other questions.
Okay.
Thank you. So, okay, go ahead.
Thank you. I want to start with the probable cause affidavit, and I think you testified that that probable cause affidavit was spread far and wide in the media over and over again. Do you recall that?
Let me be clear. It wasn't the probable cause affidavit that was spread far and wide. It was details taken from it, put in media stories with editorial comments back and forth in the context of news stories. It wasn't, here's a document from the government that was in the court record. Let me read it to you. That's not how it works. It's media coverage. That's how it's reported. Taken out of there, DNA stuff, all the other stuff in there, reported within the context of a news story.
So the news takes this document, takes things from it, and runs with it, spins with it, changes it, talks about it, and sends it out.
Yes.
Sometimes, do you think the media gets it wrong after they read something?
Sorry, what?
Does the media ever get it wrong after they read something?
Yes.
And do those stories have any less prejudice on somebody's, on the reader of that media, whether they're wrong or not?
No. And going back to, I don't care if it's true or not, my focus is to assess whether or not media coverage is prejudicial, and whether or not it's led to opinions. It doesn't matter if it's true or not. You don't say, well, I won't test all this prejudicial stuff in the media because it's not true, so I won't include it in the survey, and I'll just assume that it had no impact on people. I find it convenient to be able to disseminate a whole bunch of prejudicial media coverage, saturate the community, and then say, oh, you have no right to test the impact of that information on the jury pool. So it's wonderful that you get the benefit of generating all bias by releasing it to the media and then saying, no, you're constrained defense. You're not allowed to ask questions about it because that stuff's not true. Or you might have told one person in the jury pool a detail they didn't know. Oh, they knew the other 7 details that are highly prejudicial, but it was that one that shifted everything, and that's going to lead to the contamination. Not the thousands of newspaper stories, not the media coverage, not the stuff on social media. It was because a survey vendor called 400 people and asked a question that one person or 2 people in that panel or whatever it was in that 400 may not have known that one detail. They knew everything else. They're already biased, but it was because they learned that one detail, that's what shifted the scales. That to me is just ridiculous.
And if somebody said, I don't know anything about this case, did you stop?
Yes.
Mr. Thompson was talking to you about the difference between, in the survey, between closed questions and what can happen in voir dire.
Yes.
You're not an attorney, is that correct?
Correct.
Well, what's the difference between what you can do in a survey and what you can do in voir dire as far as your expertise?
Well, again, I sit in jury selections. I've done hundreds of them. I've done research on voir dire transcripts. I've done post-trial interviews for hundreds of times. So I have a pretty good idea of how the process works. In a survey, I can ask those case-specific media items. Well, someone says, I just recall what was in the newspaper to the open. I can ask a follow-up. Have you read or heard if David Nichols was convicted by a jury for murder? Could never do that in a voir dire because you'd be poisoning the well, just like in the John Fight case we mentioned. I rarely see during voir dire somebody admits comments on something like, oh, I read this, and then there's a whole discussion and explaining to everybody, well, that's not really true. That fact was just in social media. It's wrong. That is not a normal common thing that I've seen in voir dire.
In your experience, 15 years, you said, doing this work, have you had a situation where you've been stopped midway through your process?
No.
What do you care about?
What's what?
What do you care about? I've heard you say that whether what the media sends out there, whether all of those things are actually true or whether it's a spin off other information, that's not what's important to you. What do you care about in your work?
What I'm interested in is assessing if there's prejudicial media coverage. Inadmissible prejudicial media coverage is some of the most concerning. Misinformation is some of the most concerning. What I care about is what extent of that stuff has permeated the jury pool, what do people know, and do those specific details generate bias, prejudgment? Again, I just, the idea that there can be all this stuff out in the public that's misinformation, prejudicial, that benefits one side, and you're not allowed to ask if people know that detail because you might taint one person who already knows a whole bunch of information. But that, again, like knowing the detail about the stalking comment. Okay, that person knows all this stuff, but that's the thing that's going to change everything. And now that person's poisoned because they heard it in a survey. But the fact that there's thousands of newspaper articles and television stories and comments on social media, 80% of people in this community have talked about this case according to the survey. None of that matters. It's because I did a survey and asked that question. I mean, that's just, I don't even know what to say.
Still want to finish the surveys if we're allowed to do them right?
I'm sorry?
Will you still do the surveys if we're allowed to do them right?
Yes, if we're doing them correctly, I'm open to continuing. Now, I think this whole thing has created quite a whole new narrative that it's almost wrong that the defense is doing something inappropriate by doing the same standard survey that's been done hundreds of times in other cases, including in Idaho. So I don't know how people will respond because of all of this and what it's generated, but I would certainly try if we're doing the survey correctly.
Thank you. I don't have any questions.
Okay. So one thing I just want to sort of clear up because it's come up here back and forth with the questions that aren't true. Okay, and those were not in the probable cause affidavit. And so I think it does have some bearing on the non-dissemination order because our whole purpose, okay, both counsel were trying to protect these things from coming out to the public or to the media. That's, I think, one of the key issue, okay, or the concern about these particular statements. So there were two questions right at the end. And the ethics, okay, of the lawyers basically this non-dissemination order is really a mirror of the ethics in Idaho, especially for the lawyers who are participating in the case like this. And one of the things that is permissive for putting this information out to the public is information contained in the public record. Okay, so the public record is a case file that is available to the public. That's the law. And so to then say, well, we have these other issues, okay, of concern that have been spread through the media, hundreds and hundreds and hundreds, as you've said, that we need to test that. But then it is a tightrope to balance this. So I'm just not accusing anybody. I'm just saying this is one of the things that's pushed or pulled both sides apart and puts me in a very difficult situation. Okay, trying to make that fair for everybody. Okay, so that's what that's about. I'm not asking you to answer anything about that.
I'm just trying to think about a solution.
I don't know if there is a solution. Okay, it's out there, but it does have some bearing on additional surveys. And what you're saying is, if you can't use this, or apply the surveys that you want to complete, that you need the same questions. Otherwise, it's not legitimate.
Yeah. Well, let me ask you this.
Okay, so if you have an answer to that, that's.
Let me ask you this one. So if you said you can ask certain case, like media items, like the other 7, for example, that may come from the record. That's a possibility because you can still measure what we're talking about. These specific knowledge, when you ask these questions, is high. The more you know, the more likely they are to be prejudiced and biased. And you see differences in the ADA count or a different count. Now, you have to acknowledge there's these other stuff out there that's highly prejudicial. And we will not know if the rate of awareness of those details are as significant as they are here. So then it's an unknown. So if the argument is, well, it doesn't look so bad because all I know are the things in the affidavit, for example. Well, there's this unknown out there again, because those items happen to be some of the more prejudicial items that we found.
Yeah, this is a death penalty case. And so when we're talking to jurors, we're going to probably talk to a lot of jurors individually.
Sure.
And it's going to be on the record. And we're going to talk about them, about what they think or what they've heard in real detail. So there's that. Okay. So I guess I'm kind of wondering too, in terms of all the people that may have been called that didn't pick up the phone or don't want to pick up the phone because everybody knows, okay, that, oh, I don't know this person as my phone is ringing.
Yeah.
And I'm not, and then there are lots of people, including me, that would never answer a question, okay, on the phone. So how do you deal with that? How do you balance that? There could be, 400 people out there in Latah County that say, I don't want to say anything about this.
Yeah.
How do you factor that?
Well, so you have 2 things. So let's unpacking both those. So the jury selection question, like I'm sure you've done familiar with these. I've done quite a bit. I've done a lot of high profile ones. And from my experience, asking people in the general case, like a DUI, what do you think about DUI? And they tell you generally I'm against it. That doesn't, or I have a big issue with that or whatever. That doesn't mean they can't be jurors because it's a general attitude. It's nothing case specific. And there's hundreds of studies that show general attitudes are much less predictive than specific attitudes. This is different and unique because we're talking about attitudes and beliefs specific towards this case. That's a whole different animal. And that's the unique nature of high profile cases. So when you talk to people individually, you still have the memory issue. You still have the recall issue. Like you will not elicit everything that jurors. It's just memory does not work. It doesn't matter if they're under oath, private. There's so much research on it. It doesn't, our brains don't change just because we're under oath. They work the way they work. Your other question goes to response bias. Like what's the response rate? Is there something unique about people you miss and so on? So there's a lot of work on that. And one of the things we do is why we collect like demographic information is to see, are we missing groups? Are we overrepresenting one group or the other? If we are, is there a relationship between that factor and bias? And there's a lot of research on response rates, and what it finds is surveys that have high response rates where like everybody takes their survey, and surveys that have low response rates, where it's like less than 10%, and you compare them with public opinion polling and so on, politics, there's no difference. You find in most instances, the results are the same in surveys. So high response rates are not necessarily correlated with more reliable, valid survey findings. And that's something they've done a lot of work on because survey rates or response rates have gone down slightly. I think yeah, they have. For sure.
Well, I mean, yeah, so I mean, could be that you're just getting people who like to talk on the phone.
Sure.
With strangers.
Yeah, and from this case, I think people are so invested in it, like a lot of unique things. So people, talking about what's happening, they're very invested in this case. It's unique. It's small community. It's not surprising. But just what I'm finding, there's so much prejudgment, detail, and so on. I don't think it. I think it's fairly representative of what you're going to see. Almost everybody in this jury pool knew about the case, like comparable to like the George Floyd case. The bias was the same in terms of comparing it, not to Chauvin, who was the one George Floyd, but Alexander King, who was another officer on the scene. Like the rates are similar to that. So that was another high-profile case that was a lot of tension and stress, and so on. And we still got very meaningful data. And we've done this so many times. Like you kind of understand, like response rates are going to be lower, but there's nothing to indicate that, for example, we're missing an important group. And if we were, we would weigh the data to account for it. So there's just
so in Latah County, it was about 1% of the population.
Yeah.
So hypothetically, if we say, oh, well, I mean, one of the counties that are interested in data, which is obvious, for other reasons too. But would it be 1% of the population in Boise? No. So okay, so that's I was kind of wondering about that. You have to talk about 2,000 people or something. Okay.
Can I explain how that works?
Yeah, go ahead.
Yeah, so it's a great question. So you can take a small sample and generalize to the population if it's done correct. So like if you look at surveys of the United States, the sample sizes are similar to what we did here. Maybe it's 1,000. And now you're generalizing to every city, county, and so on across the country. Everybody has a known probability of being selected. How you pick your sample size, it's called power analysis. So remember, how you see polls of like, you'll see a number like 90%, and they say plus or minus 5%. So it's either 85 to 95%. Basically, it's plus or minus 5%. That's kind of the industry standard. And you take a conservative approach. So let's say you ask a yes or no question. You would say 50% would say yes, 50% would say no. So that's a lot of variance. So that's the worst case scenario. How many people do you need to talk to? So if that happens, your confidence interval is plus or minus 5%. It's kind of and that comes up to 400. So if you did 8 a county, it would be 400, and your confidence interval would be the same as it is here with a small anyway. So as long as it is using the general concept of a randomized sample, you can generalize that population with this.
So if I kind of interpreted this, one of your answers just a moment ago about the getting rid of the questions that are false, okay, that just came from the media, that did not come from the public, well, from the public, but not legal part. Could you go ahead with that and have legitimate data?
So I think you have the 9 questions. So if you look at it, are the other ones okay? Are you telling me there's 2 that you would like to exclude and keep the other 7?
Well, maybe. I'm not, I haven't made a decision, but I'm just wondering if, I mean, at first, in your testimony, you said, well, if we can't, I can't do it without doing the same questions. That's one of the problems, okay, the part of this argument. I mean, if maybe it can be done without sort of sending information out there that is false, that might, affect people, or looking into that, or thinking that it is, they believe in it, even though they shouldn't. Is that something that can be done?
Well, if you do it that way, there are potential confounds of things that will arise. And again, the thing I struggle with, and I understand the public record dissemination, so we've done this before. The thing I get to is like, we're not really disseminating it. We're asking if people know about detail that has been disseminated through the megaphone of the media. So I'm really trying to just track what people know. I'm not trying to pass on information through a megaphone. So I'm talking about 400 people that are talking to out of a county of 500,000 or something, the county, the plus the risks and benefits of doing it that way. It seems like there's a very low risk of undermining or contaminating the jury pool when you're doing that, versus the risk of getting a huge black hole of, well, we don't know what percentage know this highly prejudicial detail. Like, what are the odds, or like what impact is doing the survey going to have on the jury and the community relative to the media coverage that's already out there? So
Do you ever put a caveat on the beginning of the questions where you say, well, we want you to understand as we go through these questions that we're not determining guilt or innocence. We're not determining false or true. We just are interested in our your answer to our questions, and we want to be careful that we're not sending out something that you are not going to understand.
So yeah, so we do always, there's an introduction, and there's kind of like, there's no right or wrong answers to any of your questions. You could always say no opinion or I don't know to any question. It's going to remain anonymous. We're just interested in your views. And so there's an introduction to that section with those 9 items. Usually it says you may have, we're going to go through some items in the media. You may have already reported some of these already, but we're interested in what you've seen or heard. We can add a caveat to that, like some of these may not be true, if that addresses it. Some of these things were, not all of these media items are factually accurate.
Sure. People pick up the phone for somebody and they think, somebody with authority maybe, and they think, oh, well, this is really kind of the beginning of the trial or something. I mean, people misunderstand all kinds of things out there, right? So
you can certainly tweak the intro. Now, we don't just jump into it. We don't say we're an authority. It's usually.
No, I know you don't say that. I just think,
Yeah. So we can work on the introduction if that would address some of those concerns so that people understand not everything in the media is accurate. But the thing is, like, if we're going to say, for example, not everything in the media is true, they get a lot of things wrong. You would not want to say that before you do the prejudgment portion. You can do that after, when you do the case specific items, because what I want to know is, what are people's opinions about guilt or innocence? I don't want to give them instructions and then get socially desirable response in a survey.
But you don't sort of measure it, this person as their bias until you get into the specific questions, specific stuff, because otherwise it's just yes or no, and you can't determine bias just from that.
Well, no, yeah. So the prejudgment question comes before the case specific media item questions, because then you would create bias. If I read those 9 items and then I said, okay, do you think he's guilty? I just told you all the stuff you might not know. Yeah. So the question is, do you know about the case? Then it's based off of what you've read, seen, or heard about this case. Do you think so-and-so is guilty of murder, or whatever the crime is charged? And it's on a scale. Yes, definitely guilty. Yes, probably guilty. I know, probably not guilty, to based off of what they've already been exposed to without you giving them anything. So they have no information beyond what they've seen in their home. And then you ask open-ended questions like, what do you know about the case? And then other things. And then you get to those case-specific media items.
And that's when you can theoretically measure bias.
Yeah, well, I mean, I correlate those recognition items with the prejudgment questions earlier, right? So,
Correlation doesn't necessarily mean causation.
yeah. Well, they're chi-squares. You can do different things. You can do linear regression, whatever you want. But what I want to know is, do people who report later on, they know that detail, did they report stronger views of guilt? So if, like, I'll give you an example, like if you only knew 2 of those items, prejudgment was only 20%. So if you only knew 2 out of the 9 items, most people had no opinion. Versus if you knew 7 or more of those items, it jumps up to 82%. So that's telling you, like, the more facts you know, the more case knowledge you have, the stronger your opinion is, right? And that's what you see in the literature. That's what you'd expect to see.
So if somebody was being told, oh, that was just all false information, would that bring down the bias?
In what
Measure? But you were saying earlier that it's kind of pessimistic, I think, maybe, that maybe absolutely correct, that once people have an opinion, they're not going to let go of it, even if they get the truth.
Yes,
To that.
yes. It's called belief persistence. There's a bunch of research on that.
That's kind of going around the
Yeah.
political
And we see it.
things right now.
Yeah, like if you talk about, everybody has an opinion of Donald Trump, so.
I'm not going to say.
Yeah, I know, but if you,
Neither are you.
so.
All right, so thank you for that. Any questions online, Ms. Taylor?
Your Honor, I don't have any other questions for Dr. Edelman, and we do have a summary for the court at the appropriate time.
Okay. Mr. Thompson, anything online? Okay,
Sir, thank you.
so go ahead, Ms. Taylor.
Ms. Masloff is going
Oh,
to
you
give her
know what?
summation.
Okay, just 1 second. I'm ignoring the court reporter, and I'm just so immense in this that I need to worry about maybe rest. Are you okay?
Yes.
Okay. Okay, well, thank you, Dr. Edelman. Appreciate your testimony there. So, are you okay? Okay, great. Okay, let's go ahead.
Thank you, Judge. I realize it's late in the day, and I will tell you that this takes about 9 minutes for me to sum this up. But I do want to talk about something in advance because you're asking questions of our expert about his process and changing the process that is impacted in the United States Supreme Court law. And the United States Supreme Court law requires that part of the analysis for the court on presumed prejudice include false media coverage. It's not enough for it to be all truthful media coverage. So before you start suggesting that an expert change his methodology that's accepted practice, it's really important that you go back and look at Skilling and Haddon and the lineage of cases that get us to venue and what the court has to decide in determining presumption. The question you asked, be answered today, is where do we go from here in the survey process? I want to answer that question in 2 parts by summarizing what we can do and what we can't do. We can and we need to finish the process that the defense undertook. It was completely valid. It was standard in cases like this. Dr. Edelman is an expert in this field, and he has done this jury research and this work for 15 years. Nothing about the format, the methodology, the questions, or the fact of the survey itself was wrong. You've talked about 2 questions that you are describing as false because they're not in the affidavit. But if you look at that affidavit and what the media has done with those things is they have created a narrative based on the facts that are represented in the affidavit. Now, I would agree that there's a lot of information in that affidavit that is just flat not true. But if we focus on where we are right now, there are representations in the affidavit about multiple trips to Moscow from Pullman and a return trip to Moscow from Pullman in the morning that lead a reader to the word of stalking, that you have a problem with that word being included. Reflect back on the case law in the United States Supreme Court about showing false information, but also look at that affidavit and the way the media has construed that in its representations, in its reporting that is so prejudicial. Because the basis for this spin, the foundation is right there in what you are describing as the public record. Now, I fundamentally disagree that the only public record in this case is what's there on the 12-page docket. The public record in this case that the entire nation, the world, and looking at, and especially Latah County, is derived and construed out of that public record.
So can I ask you a question about that? This public record thing is really kind of circling around, because what's the purpose then of the non-dissemination order? If everything out there in the public is the public record.
Well, my understanding, Your Honor, is that it's the one of the primary issues was the credibility of the person that is out there speaking. We did not want law enforcement, 159 officers out there talking about police reports and disseminating that. We didn't want the prosecutor doing press conferences like we saw on 12/30/2022. We didn't want the defense getting up and doing press conferences based on the information, because we have information that no one else has, and we are consulting with experts that the public doesn't know about. And so we have a level of credibility that the others don't have. And so that is my understanding of what we're trying to get a hold of. And it's been pretty effective in this case until this valid survey that happens in high profile cases has been construed to be something nefarious, which it absolutely is not. As you've heard, it's been used in Boston bombing, the Parkland shooting, the Colorado theater, George Floyd, hundreds of cases going back decades. Dr. Edelman's declaration and now his testimony are uncontroverted evidence before this court on this issue. It's the actual evidence that the court, and finally today, you're getting informed about the validity and the science behind the process. Nothing that was done is worth the hysteria and the hyperbole that keeps getting expressed in this courtroom. The questions asked, the topics, the order, the open-ended, the specifics, they were all done using information that is out there for everyone to see. And the research methods used to determine what was out there is the traditional way and the scientific method that experts in this field use, just as Dr. Edelman testified. And to be sure, the purpose of this is to give you information so that you can make an informed decision about venue. It's not for a nefarious purpose. It's to arm you with facts and information so that you can apply the United States Supreme cases that have been adopted in Idaho and determine whether or not there's presumed prejudice. You know, when we first started talking about whether or not there was going to be this venue hearing sooner rather than later, Ms. Beatty for the state said at least 3 times, Judge, they can't just come in here with affidavits. This case law says that they have to have more. The more that we are gathering to provide you, at least part of it, is this survey. In terms of the proposition that this survey taints the jury pool, first of all, you heard from Dr. Edelman that if someone answers they don't know, a second question tapping into that is asked and the process stops. There's no other questions other than demographics because they don't want to poison anybody who doesn't know. So for there to be this proposition that all of these questions, these 9 questions that are later on in the process were put out there intentionally to poison the jury pool, that's just flat false. And the other point is you can't taint what's tainted. When you hear what the statistics are, as it relates to this county, 97% of the people had familiarity with the case. 79% of the people knew 5 or more prejudicial and false media reports. 81% of those who had heard about the stalking had determined and took a position that Mr. Kohberger is guilty. These people that were surveyed didn't form the opinion when they were being surveyed. And they didn't then go research their already strongly held opinion because of the survey. These are deeply held opinions in this community within this jury pool. The Latah County citizens have accepted the information placed before them by state actors. It's not just Mr. Thompson that did a media report and talked about the probable cause affidavit. Chief Fry, the coroner Kathy Mabbitt. We've got search warrants from Pennsylvania out there in the public record. We've got hundreds of search warrants in the public record out there from Idaho. We've got all kinds of pleadings. This is all information that's put out into the media. And having the state now claim this moral high ground is an oxymoron. It's a complete oxymoron for state actors to put this information out in the public and now say, hey, wait, if you want to ask if people have believed the information that we've put out there, you can't do that. That harms Mr. Kohberger. We as a defense team have the obligation and frankly the privilege of defending Mr. Kohberger and defending his right to a fair trial. And in doing so, in arguing that venue should be changed, we have to show you that there is presumed prejudice in this community. And since we have the burden of this, and you now know essentially from this expert that there is presumed prejudice in Latah County, you have to ask yourself, do you want more information to know where the better venue is? And that takes me to the next point, which is what we cannot do. You've heard Dr. Edelman say that it goes outside of his standard of practice and the scientific method that has been used for decades, that has been used in hundreds of cases to take your ideas about what should be in questions, to take the state's ideas about what's being in questions, should be in questions in the survey. He follows a process. That's the process that he needs to follow because he has to provide the court with apples to apples comparison. Another issue that has was addressed last week that I want to touch upon, and there are two, is this concept that if we just done a juror questionnaire, it would have addressed all of that. At the stage that we're at now, which is setting ourselves up for and preparing for a venue hearing, we have to justify a venue change. The standard that you're going to be looking at, according to the Supreme Court, is whether or not a presumption exists where the record demonstrates that the community is saturated with prejudicial, false, and inflammatory media publicity about the crime. The case law mentions false media publicity about the crime. That's what the survey assesses now. Another way to determine actual prejudice is a questionnaire, and that is done prior to selecting the jury. And at that time, we are looking for actual individual bias of the prospective juror. There are different methods used at different stages of the case. And right now, the proper method is a survey. Another solution that you mentioned last Thursday was simply to strike 400 people surveyed from the veneer. And I want to talk about that. First of all, that doesn't address the problem that's very clear that we have in Latah County. And so if you extrapolate the percentage of people that have drawn a conclusion about Mr. Kohberger's guilt, if you extrapolate that to the county with numbers like 81% have concluded if they are familiar with the media information about stalking, there's no prospective jurors in this county. You mentioned, this is 1%, but there's much more analysis to what the prospective jury pool is here. First of all, the jury commissioner, I think you talked about her when we were talking about whether or not jury trial was going to be speedy trial was going to be waived. You said, I think it had expanded the pool to 1,000. Am I right about that number?
I can't remember. It was maybe more.
Okay. So if you extrapolate the numbers that we know of prejudice exists, I mean, that leaves us with a very small jury pool for trying to do voir dire in a death penalty case. But if you look at the population as a whole, what the U.S. Census says about Latah County is that almost 18% of the population here is under the age of 18. Almost 18% of the population here is over the age of 65. That eliminates, close to 35% of the population that's even eligible to be in your jury pool. Second, and more importantly, I can't find statutory and legal authority for you to strike 400 people out of the veneer up front. I found the opposite. As you know, the clerk or the jury commissioner pulls from the jury pool that's approved by Idaho Code. And this is a really important section in Idaho Code 2-202. It is the policy of this state that all persons selected for jury service be selected at random from a fair cross-section of the population, and that all qualified citizens have the opportunity to be considered for jury service.
Rest assured, I was just being sarcastic.
Okay, well, I took your sarcasm to heart, I guess, last week.
I apologize.
Because it was a very serious day, right?
Every day is very serious.
Right, but last Thursday was in particularly a tough one. I think we can all agree.
There's going to be more tough ones ahead, I'm sure.
For sure. And we all need to give each other grace.
Thank you.
I will end by saying this. Our defense team firmly, and I mean firmly, believes in Mr. Kohberger's innocence. And right now he's being held to have a trial in a county that believes that he is guilty. In this country, we pride ourselves on a jury system that doesn't stand for that. In this moment, I see that you have two choices. You can let us continue and do comparative surveys as planned, or you can maintain the stay. And at the venue motion, you will hear that the data for Latah County shows a presumption of prejudice, but you will not have comparative surveys to fully inform the court. As you consider this, there is absolutely nothing that gets risked if you change venue. But if you deny a change of venue, Mr. Kohberger's constitutional right to a fair trial is denied. There's only one human being in this case with the right to a fair trial. It's Mr. Kohberger's and his alone. There's no legal right of this community to have a jury trial here. Thank you.
Thank you. Mr. Johnson?
Thank you, Judge. Let me bring this back into perspective. Our motion deals with the court's non-dissemination order. It was agreed to by the defense. In fact, the idea of the non-dissemination order was initiated by the defense with their February 30th, 2022 motion for a non-dissemination order to prevent extrajudicial statements. That would be statements outside of the public record, which is the court record, that have a substantial likelihood of heightening public condemnation of the accused. And the state's position is that the fact-specific questions, and I understand from Dr. Edelman why the questions were asked. I understand his explanation. It doesn't change the fact that we have a non-dissemination order that specifically prohibits that kind of dissemination of facts, specific facts about this case. Facts that include those that are not true, acknowledged from the stand they are not true. Which, interestingly enough, I look at the PowerPoint and slide 15, which talks about the American Society of Trial Consultants Professional Code on Venue Survey, says false facts should generally not be used to test accuracy of other responses in venue surveys. So if false facts are used, they must be clearly false. There's no possibility that the respondents who know about the case use false facts with true facts that have been publicized. We have an inconsistency there, which frankly is logical. It makes sense. And the state is coming from a position of being practical and trying to use common sense here. As I listen to what we have heard today, and in part from last week, it seems that the position of the defense is it is okay to risk tainting additional jurors in order to ascertain bias of other potential jurors. And I'm not sure that's the way this court should do business. If we accept what the defense is suggesting at this point, and again, we are not arguing venue today, and so I'm not going to try to get into all these numbers and all those sorts of things. We'll save those for another day. But if we were to accept that we have perhaps on one issue 20% of the jury pool statistically available, well, that's more than enough people to select a jury from. So it's not nearly as overwhelmingly compelling as I think is being suggested here. I want to be clear again. Ms. Massoff used the word nefarious several times, suggesting the defense was, or that the state was accusing the defense of being nefarious. And sure not, Your Honor. I am not suggesting that there was any ill will or motive by anybody over here. What we are suggesting and what we believe that the record shows is that this court issued a specific order prohibiting the dissemination of specific types of information, including the identity or nature of evidence expected to be presented, including the performance of results of the examination or test. There's no question that those 9 questions included violations of the court's no contact order. That's what we're here about. And apparently there was some miscommunication or misunderstanding about the integrity or the importance of the non-dissemination order. It sounds like today that maybe because these types of surveys are common nationwide, then the non-dissemination order really doesn't matter, which is a little disconcerting, but I don't care about what happens anywhere else. All I care about is what happens in Latah County, in this court. It's far above my pay grade to go and analyze what happens in a big city or some other part of the country. I know Latah County. That's where my interests are. That's where our interests are here. On the issue of whether the survey can be changed, I think that does present some challenges based on what we've heard here today. But the solution for that is very easy. We just back up, and if the defense wants to pursue the survey, they do a new survey with a new group of people and take out the objectionable questions. And then once they've done that, they can proceed to do that identical survey in other veneers around the state, whichever ones they want to select. And that would be the proper way to do this. Now, we may hear, oh my goodness, that's going to consume time, or that's going to consume a lot of money. Well, I'll tell you right now, I don't care. If it can't be done right, or if that's what it takes to do it right, then we need to do it. This is a big case. And the finger for this cannot be pointed at anybody but the defense. I'm not suggesting an evil intent, but the practical effect of the decisions made on behalf of the defense was to ask these questions and to create a situation that we've been having to deal with now for 2 hearings over the past week, well into the evening on a Wednesday. That's the way forward, Judge. Thanks.
Go ahead.
Judge, I'm just gonna end really quickly with this. We didn't violate the non-dissemination order. You know, the information that now he's calling facts, you know, he's flip-flopping between whether or not it's a false fact or a fact that's in the survey. The information that was put in the survey is based on the public record and information, the way that the state and state actors put information into the public record that has now been disseminated. And we have not violated that order. And I do resent being accused of that.
I appreciate that. I mean, those 2 questions were not in the public record. Okay. They were. I mean, they came out, but that was not the court. I mean, where it came from. It just came out of the media or somewhere. Who knows where it came from? But I don't think there's anything, not that I'm aware of, in the public record that said anything about that, about your client. So, I mean, here we are. I mean, that happened. It's kind of unfortunate. I totally understand the reason to have false information out there, but I mean, I have to just want to clear that up. The other questions, that's all from the public record. I don't question. But anybody tell if you can find somewhere in the public record that those claims were made, I'd like to see it. But I think both sides are looking at a different definition of what public record is. They've looked it up. It's the public record from the case. So that aside, I appreciate the testimony, the arguments from both sides. I think it's a challenging issue. It's something that I'm going to have to struggle through and figure out what to do. And I understand that there's some urgency to get that out, so I'll do my best. Probably not going to be this week. So, anything else we need to talk about? Ms. Taylor?
Your Honor, just the logistics of the court's decision is yet to come. We can't continue the surveys. And we've got deadlines next week, midweek for briefing and the motion for change of venue for May. So I'm wondering if we want to consider resetting that motion and that deadline now. I still want to keep the hearing on May 14th. We have a motion to compel already filed to be heard that day. So we could still use reserved court time to make some further advances in the case. But I'm concerned about being properly prepared for the change of venue waiting for the decision, especially if we're allowed to continue with work.
Sure, and I told you last week that I would give you more time. I won't be fair. So you want to change that hearing, you want to leave the May. We're set on May 14 at 1:30.
We have,
You want to keep that for the motion to compel,
yes, please.
but you want to move out the hearing on change of venue.
I believe that's the only prudent thing to do at this time. Yes, Judge, I think that we should, based on some availability of team members and experts, though, I think we're not ready, or we won't have the team available until the 4th week of June for all of the people that are necessary.
You want to just wait and just talk to each other, just, have a hearing again.
Judge, I don't
I
think we're gonna have an agreement on the change of venue issue. If I thought we could come to an agreement on that, I'd say, yes, let's not set one, let's talk.
Oh, no, I'm not suggesting that you would agree on agreement on change of venue. I just mean changing the hearing, the date.
Your Honor, we would suggest the last week of June, and if the prosecutor's ready to weigh in on that and the court's ready, would prefer to get a date now.
Okay. Mr. Thompson, what are your thoughts?
Yeah, I think it would be appropriate to reset the dates, and really what's going to drive this in part, well, in large part, will be your Honor's decision on what we've been talking about today. But I think it may be prudent for the court it would be prudent for the court to vacate the hearing on a motion for change of venue and prepare to reset a briefing schedule and a hearing date on the motion for change of venue to a reasonable future time,
Okay,
to allow the parties to react to whatever the court's decision may be. And I don't want the court to feel pressured on the timing of its decision. I'd rather take the time to do it right than to rush things and just bollocks it all up.
well, I won't rush it. And I will feel the pressure.
Appreciate that, Don.
How about we set this for 1/3? We'll vacate the hearing on change of venue and reset it for January 27. That's a Thursday, which seems to be a good day for this generally, except today. What did I say? June. Sorry,
Your Honor,
it's a long day. June 27. I thought you said the end of June, right?
June 27 is perfect. I am thinking, though, that we should maybe schedule for a full day. We estimated an hour for this, and we're well beyond that now, and we anticipate testimony.
There's 10 o'clock. Will that work?
It will, thank you.
Okay. And work for you, Mr. Thompson?
Yes, sir. We are available that day. At least those of who were right here.
Okay, and that includes Ms. Jennings.
And hopefully Ms. Beatty and Mr.
Well, I'm gonna ask them next, and then I'm gonna go to Ms. Massa.
I'm good.
Okay, great. Okay, Mr. Nye and Ms. Beatty.
Yes, Your Honor, that date and time works for us as well.
Okay, perfect. Okay, 10 o'clock, June 27. Okay, is there anything? Oh, yeah, briefs. What do you think, Ms. Taylor? I mean, I know you can't know until I give you a decision. So,
Your Honor, the briefing schedule that the court gave us was roughly about a month prior to the hearing. We could try that, but if the court's decision takes a while, and if we're allowed to finish our surveys, then we might have to have some time to do a supplemental.
sure. I'll be flexible about that. Let's say hypothetically that we have more surveys, then we might even have to push it out.
That's
I-
possible.
Yeah. Especially, well. Yeah. Mr. Edelman, Dr. Edelman told me that, you don't necessarily, if you go to a larger population, that you have to have a percentage of it. It's just. And with, I think, the magic of statistics.
Your Honor, if we're allowed to finish what we started, we think from the time we could get it going, it would be 3 weeks. And then Dr. Edelman would need a bit of time to assimilate the data into a report.
You think, if all went well, that, you could have your briefs or whatever other information by May 31st?
Yes, yes. Your Honor, with a caveat, unless there's a long delay.
Caveat, okay?
If there's not a long delay in me knowing what we can do, yes.
Thanks. What do you think for the state, maybe a deadline of June 14th? So,
Actually, I think that Ms. Beatty is going to be handling those venue issues. So how about we ask her?
Okay, Ms. Beatty?
And Your Honor, Mr. Nye and I will both be handling that, but that works for us.
Okay, fantastic. And then maybe a reply by June 20? You think?
We can do that.
Okay. That'll give me time to look at all that before the hearing on June 27th. All right. Thank you for your patience. Anything else? Then we have to talk about this one motion. You said we'll put it at the end of the case, and the end of the day.
Oh, the prosecutor's filing. Yes, I'll take
Yes.
a look at that with him before I
Okay.
leave the courtroom, Your Honor.
All right. Is
We-
there- Go ahead.
If the issues that I have, if they're redacted, then we'd have a stipulation. I'll just show them what I was talking about.
Let's see if we can do that.
You two can.
Yes, sir.
do all that. Okay. Anything else then? Ms. Taylor,
No, Your Honor, thank you.
Mr. Thompson.
No, sir. Thank you.
Okay, thank you for everybody's endurance and have a good evening. Thank you. Sorry for such.
Well, that was something else. I don't even know how to feel about it. I feel like my brain has been broken, if I'm being honest. Like, what was that? What was that? So basically all that you missed, Brendan's just sitting down now, is scheduling. You didn't miss very much. I think I had in my notes, like Anne was just asking, because of all this, and they're gonna have to have another hearing, and they're waiting his decision essentially, and so they can't continue the surveys. So she needs a new hearing. They have to delay this again, the change of venue hearing. So that's going to be on June 27th, and she said they're going to have testimony. So let's put it in for like a full day, and because they thought this was only going to take an hour. That's what they planned for, was for this to take an hour.
Yeah, I don't think they planned for Bill. I got to tell you,
I don't think they expected him
why
to
were you asking if I was
see.
back and you could use the restroom or anything?
No.
Okay.
I don't think they expected Bill to look at like the facts and then just outright act like he never heard them and deny them.
Look,
Or the judge. I feel like the judge was kind of doing that a little bit too.
I've said this from the beginning, okay? If somebody on the prosecution's team, again, you guys, most of you know, we try very hard not to be biased in any situation. So when I'm looking at this case and I'm looking at the prosecution and the defense, right, from unbiased eyes, the best I can, everyone's biased, but the best I can from unbiased eyes, I see a very different experience level in this hearing, in my opinion. The last hearing, I didn't see any experience level. The last hearing was Hollywood soap opera, okay? This hearing,
Yes.
we're back in the courtroom. However,
last hearing was so emotional. This hearing, much more objectivity. We actually heard evidence. We actually heard a witness. And mind you, he was incredible. He killed it up there. He killed it.
Expert you could ask for. And wherever he got his presentation training from, because I do think that he had some public speaking training, sales training, presentation training. It's all the same, okay? He was very good. You could see the change in tone when he was building rapport with the judge.
Well, and I think he realized he needed to have that one-on-one conversation with Judge.
Agreed.
To like, I just think he knew that needed to happen. And that's why he kept continuing it and he kind of pushed for it. Because in the beginning, Judge wasn't really like gonna let him talk.
Yeah.
And then he kept pushing like to talk. And then it started this dialogue that I think was really, 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 really good and beneficial. And I hope that sways the judge's opinion. And I really hope everything she said was spitting facts. Like, she was so assertive and I love it. Though I don't know if that works with Judge. I hope it does. Maybe he just needs a dominant woman to get up there and tell him how it is, you know?
Right. And look, maybe I don't know. I have no idea. I know that, like I was saying, the difference in experience level, in my opinion, was so insane.
Did I grow a gray hair?
So insane.
Do I have gray?
The presentation of Bill. So when I'm looking at it from an attorney, and you guys, I have no experience in legal. Okay. I have never been involved in anything related to legal advising, an attorney, anything of the nature, period, point blank, ever, never, ever. But, in this situation, though, I saw so many different opportunities where Bill Thompson could have truly objected for real, where there was some expert bias in his presentation because he owns the company, okay? He is the owner of that company. There's going to be bias in the presentation.
I agree.
Based on the company. And Bill Thompson, if he knew the right areas to pick out, right? I think he could have objected and he could have got that presentation halted, at least had them stop presenting the slides, which I think was his ultimate goal in this situation.
He did not want those slides up there because he did not want that data up there. That data was damning.
Yes,
and also explaining the fact that, hey, we don't ask these questions,
50.
which, hold on, I want to pull up the outline to that. We don't ask the questions like that. Have you read, seen, or heard? We don't ask those unless they recognize the case.
Yeah.
So if they know nothing about the case, they do not get asked any of those. Have you read, seen, or heard? They don't get asked any of those. So it's not disseminating information to the people who know nothing about the case, which are the perfect people for questionnaires. They get directed straight to demographical questions and how much they consume media.
Agreed.
That
I
is
agree. And
such a good fact to know. And that fact alone instantly takes away any doubt I had in this survey at all.
I agree with you, but look, one thing that I want to point out, though, that we were briefly talking about, that we wanted to save the conversation till we were live and our mics on and everything, is the fact that Bill Thompson has pointed this out in general, now has prepped Latah County of how to answer and what to expect. The fact that this was even brought up at all,
I know
the questions are blown.
he biased the jury.
He did. He biased
He
the
violated the non-dissemination order.
I don't think anyone violated the non-dissemination order,
He
because
did.
all that
He did
information
in this hearing.
was
You
public.
weren't here.
Oh,
He
yeah,
said
okay,
the
okay,
stalking
yep.
allegations were not true.
Got
Point
it.
blank, period.
Yeah.
He literally violated it in that hearing.
Yeah.
And if
Yeah.
I did, like, if I believed he violated it by reading the questions in the first place and then saying
Mm-hmm.
that there were things on there that weren't true, and automatically you go to, okay, what's not in the PCA? Oh, it's the stalking and the following victims on social media. And then in this hearing, he takes it a step further and is like, oh, the stalking, the fact that Bryan Kohberger stalked one of the victims, that question, that is false.
Take it over for a minute. I gotta put on an AC.
Okay.
fan.
It just blew my mind that he outright said that. And he was so flustered. Like, that whole time we were watching his face. And that's part of the reason we were dying laughing, is his face just got redder and redder and redder. I was genuinely getting concerned. He needs like medication. Like, I don't know, is going to have a heart attack. Like, every time Bill Thompson has lost his cool in the courtroom, he's been red like that. And this was, I think, one of the worst times. It was wild stuff. I don't know if you guys were looking at our faces at all throughout that, but I was losing my mind. There was one part where Brendan couldn't stop laughing for like 10 minutes. I'm trying to remember what he was laughing about. But okay, so let's back up. So I want to go to, so if you guys hopped on and didn't see the whole thing, essentially the hearing, the first 20 minutes of the hearing is them arguing back and forth, and Bill just doesn't want to give it up. He doesn't want the court to see the PowerPoint that Ann and the expert Edelman, Dr. Edelman, who is a PhD in psychology and all this, stuff about like surveys and human psychology when it comes to the courtroom and law, which is incredible. And he has 15 years experience, and they prepared this PowerPoint. Bill Thompson really did not want that scene, and he wouldn't let it go. And Ann just she got very point blank eventually, and it's like, look, we're 20 minutes in. I suggest, Judge, you just listen to the expert himself, because you need the information to be able to make an informed decision. And I feel like Judge realized there's reason in that. And yeah, like, I need to just hear it from the expert, which I'm glad that he made the decision to allow the PowerPoint to be presented. Because if he had not, honestly, I think if he had not, how do I say this? Like, if he prevents evidence from expert witnesses in this case like that in the pre-trial phase, like, I really think there could be a real argument for a Supreme Court appeal. Like, if the defense isn't allowed to be heard, because that's part of them being heard. That is part of due process. Them being able to present evidence and make a valid argument. If they're prohibited in doing that, their due process is being violated. So I'm glad that he made the decision to actually look at it, and also for like personal reasons, I guess, like for the reasons of honesty and integrity, hearing the evidence, looking at the facts so that he can make a solid decision on whether or not to continue the survey.
Yeah.
Then, the expert gets on, and Ann goes through all of, these questions about the process. And it was really fascinating, the process. And it's exactly what I thought it was. That open-ended questions, people don't recall. You get way less honest answers. That makes so much sense to me.
Yeah.
Because I have a terrible memory. And I used examples last time we talked about this. Like if somebody asks you about, have you heard of the Taylor Brown case? That's the example I used. And you're like, well, no, I don't recognize that name. I'm not very good with names. Or if you ask, did you hear about the little girl that went missing last January? She was, a white little girl with brown hair and blue eyes. Like, then you're like, oh yeah, okay, I know who that is. And I remember that being reported on the news.
Yeah.
Like things, you have to say things that jog people's memories to get honest answers. And one theme that the expert in the defense kept really pounding this in, which I think is important and good, is that, especially the expert, is that if you don't ask these certain questions, even if they're false, if you don't ask the questions that have been widely disseminated across the public, which is, since we know that Bryan did not stalk one victim, Bill Thompson himself said that's false. If we don't ask that question, then there's a black hole of data.
Yeah.
That's a very prejudicial fact. And you guys know, because all of us care so much about this case, that is a major, major piece of information that people hold against Bryan Kohberger and use to say he's guilty. Look, there's all of this. That's why the cell phone data, we have covered it extensively.
Yep.
Because we know it's BS.
Yep.
We know it's BS. We know they don't have proof when it comes to triangulation data that he was stalking these victims. They don't have it. May they have it in other ways? May they come out in trial and say, well, no, it was false. He wasn't stalking one victim. He was stalking the home.
Right.
That could be the truth. It could be he was stalking the home. It could be that they have geolocation data. It could be they have something else that is not triangulation. All we know is that they do not have triangulation, and he was not stalking one victim.
Yeah.
And he was not following one on Instagram.
Yeah. To be fair, though, because I don't want to present that biased. It could be more than that. Like you had mentioned,
they could have more. They could have other things.
Maybe he was stalking all victims just to look at it from the other side of the coin
home
here.
as a whole.
Right.
Yes.
Right. But that idea that he was stalking Kaylee Gonzalez or any
Madison
one
Mogen.
of them,
Madison Mogen is one that's mentioned all the time too.
Or any one of them. Yeah, I agree with you. I think that that's huge, and that is the
extremely
only piece of
bias information.
That's the only piece of information that came out during this hearing and the last hearing that the public didn't know. That's it.
Yeah.
And
now everybody knows it. And Bill Thompson is the reason everybody knows it. So he violated the non-dissemination order, but he will not be held accountable, which is BS, in my opinion. I don't agree with that.
It isn't fair.
Considering he's out here, when I consider the defense doing something that is totally okay and there's nothing wrong with it, and it seems standard and very high profile cases. All the cases cited are some of the most high profile cases in the modern day that have ever happened. And this survey has been used in all of them. So the fact that they're doing this, it's perfectly okay. And for him to come out here and accuse the defense of violating the non-dissemination order, but then violate it himself and waste everybody's time. You didn't hear it, but at the end, he said, I don't care if we're wasting money or time. If we have to do it this way and make the defense completely start over from scratch, we have to do it. What do you think about that?
I mean, but again, going based on what we've seen lately, from Bill Thompson, it doesn't surprise me. It's not surprising to me, because we have because the level of experience is completely different, in my opinion, between the two of them. And it hasn't been as apparent, like I was saying, as it is right now. Right now, during this hearing, completely separated them. And that's where I was going that I didn't get a chance to say is, look, I've said it now for multiple hearings that if Bill Thompson is going to continue grandstanding in this way, someone needs to train him how to do it because
he
everyone
sucks at it.
Yeah, everyone can see through it.
Yeah,
his experience isn't there.
It's not,
and it's sticking out like a sore thumb. And what he's saying and what he's objecting about in today's hearing doesn't make sense. None. Zero.
No.
Absolutely no
it was
sense
like
whatsoever.
It was like he was gaslighting everybody.
I agree. I agree with you. It drove me mad and it made me feel bad for him. I couldn't help but feel bad for Bill Thompson because how he was presenting it, you could see such a weak argument. Like you guys, I've shared with you a million times before that I'm in sales. Okay. I've been in sales and it's network focused, right? So I have the network experience and sales experience. And when I'm talking to somebody like a CEO or CFO, when I start seeing the personal presentation that I was seeing from Bill Thompson, I either know that person doesn't want to talk to me and like, we got to pick this up some other time, or they're just flat out lying to me. It's one or the other. And there's not much in between because you're just showing your colors. You're unconfident with what you're saying. You're not to mention his physical appearance, which I heard you talking about when I was turning on the AC, but
what, his red face?
Yeah, his red face. Yeah. Which there's nothing he can do to help that. Like,
no,
there is
he
absolutely
can't.
nothing that he can do to help that.
I was just seriously concerned. Like, someone that gets that red eye, I'm seriously concerned they could have an issue, you know, like physically.
Yep. So but huge shout out to Regina. So we have OMG, but not in disbelief. Congrats on 31.9K. I haven't looked at your subscriber count in forever because I'm always chatting or pushing the thumbs up. We appreciate that. I didn't even realize what our subscriber count was at.
But that's amazing. Thank you guys so much.
That is amazing.
For always supporting the channel.
Yes, you guys
it's
are
great
awesome.
Knowing that we can count on you guys and that you're enjoying the
content.
I did want to give a shout out to Strange Suspicion. And we did say hi in the chat, and like I did put up like AR Hayes too throughout a little bit here.
And so thank you, Regina.
Yeah, here's Strange Suspicion. She's a content creator. And, you know, I have caught quite a few of your videos here and there. We don't always have a ton of time, you know, to
I've watched
to watch content, but I just love the vibe of her editing. It feels so nostalgic, you know?
Absolutely.
It feels almost kind of like old school MTV type editing. Like, if you know what I mean, like the cut and paste, like, I don't know. Something about it feels like kind of old school grunge. I don't know. I really like it though.
Yeah, for sure.
And the content, period. How?
Yep. So,
but yes, we appreciate you and we really like your content. So definitely go check her out. And AR Hayes is also in the chat.
Yeah. And they're both content creators. Here we go.
Yes.
Yeah. So check them out. They are incredible. They stop by and hang out with us quite often. And
And I think he might be right.
What?
But yes, we appreciate you also, AR. AR is always here supporting. And he's got great content too.
Yeah, I wouldn't be surprised by that either, you guys. We've heard a lot of different you know, through the grapevine comments about people having an undercover rat, you know, a jailhouse snitch is exactly how it was said actually
Yeah.
on multiple
And
occasions.
those strange search warrants for the forensic lab
And-
might be an indicator of that.
Yes, absolutely. And what's interesting is Steve Gonsalves said it, and I don't know if I don't ever want to feel like I'm putting someone on blast, but Steve Gonsalves said it, and Steve Gonsalves was working directly with Olivia of
And a private investigator.
Olivia's channel?
Chronicles of Olivia.
What is it?
Chronicles of Olivia.
Chronicles of Olivia. And so they are working with Chronicles of Olivia, and then she comes out and says that, says that there is a jailhouse snitch or whatever, and it's pretty interesting.
Yeah. Tell me real quick, how do I get to the banned words?
There's nothing you can do.
Yes.
No.
You can't ban a single
No.
letter?
Mm-mm.
An N?
No.
What?
No, you can't. Nope. So we're just going to keep going. Don't even worry about it. It takes 2 seconds. I'm not worried about it. But they're just trying to drop our concurrent viewers. But anyways, moving on. So what other notes did you take down? I don't want to get sidetracked by them. It's not worth it.
So getting
Don't
into
even pay attention to them. I don't care.
the data that was brought up, because and then we're going to talk about Masseth, because Masseth came in there with a huge mic drop moment.
Yeah.
Like
yeah.
Masseth
Huge.
absolutely killed it on the stand.
50.
Like I just cannot. She
50.
killed it.
Yeah.
She killed it on the stand. So I took a bunch of screenshots of the slides as they were coming across the screen, because I wanted to come back to them because it was fascinating. So survey respondents provided an average of 1.6 details when asked, what have you read, seen, or heard, which I believe that changed at some point. I was getting a little confused because then at one point they said it was over 4. So I think there might be some differences maybe in like the
Did you screenshot all those?
I did screenshot them. It says 96% of the survey respondents failed to mention at least one media item in the recall question they later recognized in the survey. On average, they recognized an average of 4.9 additional media items. Okay, so that's the difference. That's what I was wondering. Okay, so the 1.6,
I'm listening.
that's of all respondents, I'm assuming.
Okay. Oh, that's a bad quality image.
Because then they're talking about the respondents that failed to mention at least one media item. On average, after they failed to mention that, they then recognized 4.9 additional. I think that's what it's saying.
Yeah, let me see. Recall question they later recognized. Yeah. That's just a basic statistic, though. So
what do you mean?
So what they're doing is they're giving you an outline of of like why it needs to be done again a certain way, and it within that they gotta let people understand like what the base user is, you know what I mean? So so if you're giving a breakdown on a statistical probability, within that statistical probability you have to give people the value of that statistic. So like you can't come out and say, hey, look, the people that we're looking at are this percentage likely of believing Bryan Kohberger is guilty, without giving a baseline of why those percentage of people believe that. You know what I mean?
Mm-hmm.
So that original statistic wouldn't make sense. Like that, like what I mean is that statistic that you're talking about doesn't actually add to the argument or value of the of the argument in court.
Well,
It's
this
giving
is
you
okay.
it's building the structure of the argument.
So this is what I actually thought was like really fascinating though, and they didn't actually read through this. But there's this chart that they put up, and it says it has all of these questions. So it says, what have you read, seen, or heard about the accident or this case? And then the next column says recognize item but failed to mention it. So just what has been seen on the TV and the papers, 9 out of 9 failed to mention that and recognized it. Remember, just what I have read or seen on the news, 9 out of 9 recognized but failed to mention. He stabbed the people to death. 8 out of 9 failed to mention it. They tracked him and found BLOOD. 7 out of 9 recognized but failed to mention it. That he murdered
Recognized but failed to mention it.
4 people.
Okay.
7 out of 9 recognized but failed to mention it. Nothing lately. Like, what does that mean? Nothing lately? 7 out of 9 failed to recognize it. Like, that's really confusing.
Yeah.
Survey respondents failed to recall an average of 4.9 items they later recognized in the survey. In all of these, it says the average, so they take all of these and they come to an average of 4.9. Yeah. What are you doing? 79% of survey respondents recognized 5 or more of the media items. 82% of survey respondents who recognized 7 or more media items reported that Kohberger was guilty. That is an interesting statistic.
It is. I
because
think
that's
an
very
interesting
high. That's
statistic.
82% that recognized 7 or more media items reported he was guilty. And 79% of survey respondents recognized 5 or more of the media items, meaning the amount of people in that county that think he's guilty is very high. It's well over 50%. Well over. 81% of survey respondents reported that they had read, seen, or heard this media item, and this is not talking right. This is specifically about the knife sheath on the bed next to the victims. 81% said that they had seen this media item. 8% mentioned it. Only 8% mentioned it when asked if they had heard of it, which is interesting. That's super low.
Yeah.
Only 8% mentioned the knife sheath. Like,
No,
that is
I
one of
agree
the
with
biggest
you.
facts of the case.
I agree with you.
%72% of survey respondents who recognize this media item reported that Kohberger was guilty, compared to 47% who did not recognize this detail. And that is something straight out of the PCA. Literally, like, one of the biggest pieces. But these numbers can get a bit tiresome and boring. So, wait. The source of most
Yeah,
okay, so this is
I'm not even going to comment on it, you guys, but
just don't pay them any mind.
no, just block them.
Block them, report them, don't pay them any mind. And we're not going to either. We're going to continue the show like they don't exist. But there's also a slide that mentions all the prejudicial media items. I think we could all guess what that is. You know what I mean?
Yeah.
Like, I think we can all guess what those things are.
Yeah, I agree with you.
So let's go on to Massive. How did you feel, everybody, when Massive said they all firmly believe in his innocence? And she's actually not the only one that said that. And
Okay.
Taylor said that too.
Yeah.
It wasn't her speaking for everyone. It was speaking for herself because she felt like because that was after the judge said, I'm trying to protect your client. And she's like, hold up. He's my client. Like, I am not trying to do anything to hurt him. I firmly believe in his innocence. And every decision she's making, essentially, and I'm paraphrasing, is for his benefit. I feel like her integrity was being kind of called into question by Bill Thompson and the judge, acting like they're trying to protect Kohberger because she's not.
Yeah,
I called that out last hearing too, because that's exactly what they were doing. They were claiming they were protecting him from her decisions.
Look, I agree with you. And we talked about that in depth last hearing too, that anytime somebody prefaces a statement like that in court, especially when it's an attorney that has a specific outcome they want in any case, you can almost guarantee everything coming back out of that is untrue. You know what I mean?
Mm-hmm.
And this idea that Bill Thompson wants to protect Bryan Kohberger from having an unfair trial is hilarious. It is absolutely hilarious.
It's very hilarious.
Yeah, because it doesn't do anything for him. So there has to be buy-in here, okay?
Exactly.
And without there being a buy-in for him having a fair trial, I just have a hard time with that one. I
do as well.
But so one thing I do want to talk about is that expert's experience, before or the last hearing, okay? The last hearing.
We're supposed to be talking about Masseth, but
I got you. You were just looking something up, so I was filling the air. What else you want to talk about?
Go ahead, finish your thought. You should finish it.
We're gonna end up talking about that for a while, so we should finish that.
I mean, Masseth was a huge deal. Everything she said was incredible. She mentioned that. Okay, so she basically said the media has taken information from the PCA and spun it and disseminated it and prejudiced it, is essentially what she was saying. And she straight up started, like, I feel like, attacking Bill Thompson for everything that he's been saying. And she basically said she was highly offended at his accusations.
I know.
That what he's saying is super, super offensive.
Well, yeah. And everything that
the expert was offended by Bill Thompson's statements too. Because he put all the blame on him and called his reputation and integrity into question.
I agree with you.
And Bill Thompson acted like he was surprised by that. I'm surprised as someone of your experience, to cry about it. And he's like, I'm not crying. I have 15 years experience and you're calling, my reputation into question. Like, I see why he was upset. I totally understand why he was upset by that.
Yeah, no, I agree with you. And here we go. Okay.
What are you doing?
Just so people can know who we're talking about, because some people that watch us are visual people. So I think it's helpful to share an image of who we're talking about. So yeah.
Yeah. And then she said the state playing this moral high ground is an oxymoron.
I agree.
And she said, do you want to know, like, actual information to know where the better venue is? Because this survey shows bias, like, point blank, it shows bias in this county. And without continuing the survey and doing it in other counties, you're not going to get the information you need to be able to pick a better choice.
Yeah.
And she called out the judge too, and essentially said, before you start telling an expert to change their process that's backed by the scientific method he's been using for 15 years, that you should look into. She cited a Supreme Court case and some things the judge needs to read before he starts telling an expert to change what he does, his process that's been built over time and based off research and all of these things.
Okay.
Did you hear that part?
No. I missed almost the entire statement. So this is helpful for me. I caught the very beginning and the very end of
She
it
also
and missed everything in between.
Well, this is a really important statement she made. She said the juror questionnaire that they do in, you guys, I can never say voir dire or whatever it is. How do you say it? Do you know how to say it?
Voir dire?
Something like that. I can never say it right.
I was totally guessing, you guys.
I'll work on
I'll work
on my pronunciation of that word, okay? But it's the jury selection process, okay, with the fancy name. When they do the
Someone said voir dire. Okay.
Voir dire.
Makes sense.
Okay, thank you. Yeah. So when they're doing the jury questionnaire for that process, they're looking at bias in individual jurors. That's why, and at that time, it's important. Like, you're at that point where that's important because you're literally selecting a jury. The jury survey is important now ahead of that time because you're looking at bias in the communities before you try to see an actual jury. You're looking at the public at large, which is what this survey is doing, because there kept being this argument where, oh, just a jury questionnaire would do all of this and it's on the record and it wouldn't bias the jury. Like, a jury questionnaire is almost enough or something. And that it would address all of these issues when that is not true.
Yeah.
It would not.
Yeah.
And I thought that was really important for saying, you know, the jury questionnaire focuses on the individual. The survey focuses on the public at large and determining bias in the community. And she also excluded 35% of the population in Latah County based off age. And then she's like, she said, you have
that makes sense,
no,
though.
you have
We
no,
looked at that the other night, and
she said, you have no statutorial, like, legal jurisdiction, basically, or authority to strike 400 jurors. Like, there's literally, the judge has no basis to be able to do that.
yeah.
And she said she found information actually to the contrary.
Yeah.
And then, you know, at that point, Bill comes on and he just points everything back in the defense's. He just basically points a finger at them, you know.
Mm-hmm.
That's what he kept doing, is he just keeps putting it back on the defense. The defense wanted this non-dissemination order, which really bothered me. Why are you acting like you didn't want the non-dissemination order? Like, you want it just as much as they do, because this is a theme in Idaho, okay? Especially northern Idaho. There is a theme of secrecy in the judicial system.
Yeah.
There just is. They hide things. That's what they do. And, you know, I don't know. I think we're going to dive deeper into that topic and the actual communities and how they hide things more in the future, because it's really interesting. Like, this is not a new thing. This is very much a part of their process, and it's intentional. So, I mean, to act like Bill Thompson didn't want the non-dissemination order is ridiculous. He just wants to be able to determine himself when he can disseminate information and when it shouldn't be disseminated. Because what did you think about the recording that they played of Bill Thompson?
I just wish I could have seen his face, man,
I know.
the whole time.
We got to pull that clip because he's saying, now, when we get the PCA, or when, you know, Kohberger gets here, we're going to send out the PCA and we want you to share it far and wide, spread it far and wide, the facts of the case, you know, to your readers and listeners and people interested or whatever. I was like, no way. Did they just do that? Looks so bad.
I honestly wish I could have seen Bill's face. I wish I could have seen Ann Taylor's face, and I wish I could have seen the expert's face. And you know what's interesting is the judge looked so embarrassed, dude, when the
know.
cameras were back on. So
I
for
know.
you guys that aren't in sales, a major tell when you're talking to someone that they're uncomfortable, that they're embarrassed, that they're unhappy with the situation that's going on is them putting something in front of you and their body.
Yep.
It's an even bigger sign, a more likely chance that something's wrong or something's going on when they cover their face. The judge was like this.
I know, he was hiding. And there was some points where he looked like he was literally trying not to laugh.
Yeah.
Out of uncomfortability and embarrassment. Because he was just like, what is happening right now?
Yeah.
Because Bill Thompson looked like, I'm sorry, he just didn't look like he knew what he was doing. If I'm just being honest, he looks extremely unexperienced. He looks unprofessional. I mean, he just doesn't look like he knows what he's doing.
I agree. And I said it the whole time. It makes no sense whatsoever. When he's presenting his arguments.
He doesn't.
Yeah.
And him getting all flustered and, you know, even though he claims it's not personal, he makes it personal. It just, that even more tells me, I don't know, maybe it's a tactic of his. Do you think that's a tactic?
No.
To make things personal? Or do you
No.
think it's like he's all up in his feelings for real?
I think he's all up in his feelings for
I agree. I agree.
When you hear someone talk and they're like, I don't know if I can do it on cue. I was trying to make my voice shaky like Bill does. Okay. When someone is talking and they're really uncomfortable, you'll hear that shaky pitch in his voice. Look, that can't be controlled. That is not, that's proving that he's uncomfortable. Absolutely proving that he's uncomfortable.
Wait. What did you think about when the judge said, then what's the point of the non-dissemination order?
Dude, right. I know it.
I'm like, yeah, judge, what is the point of the non-dissemination order? What is it? Can you tell us? Because I only see it as secrecy for no reason. Just to cover everyone's butts. Now, I don't know. What did you think about the explanation from the expert and the media coverage in question? Like, and the contribution of content creators to that and mainstream media as a whole. Like, should we be taking apart these documents and giving our opinions on them? Because it calls that into question. Because he said, you know, they're not taking documents and reading it outright to the public and you know, that's like it. They're not doing that. Honestly, it sounded like they didn't agree with the PCA being out there at all. Which is interesting to me. Normally a PCA is put out.
I mean, it's interesting to me because it made me second guess this hearing because I was like, wait, how do they not know their own court record?
What do you mean?
So if you're a prosecutor, if you're a judge, if you're a defense attorney, you know what the court record is. You know how often you're probably in the court record. Why does the judge and Bill Thompson act like they didn't know all this information is, you know, the second click down or whatever it is?
I don't know. The judge kept saying, so one thing that was a point of contention between the judge and the defense is saying public record as in everything that's in the public, mainstream media, allegations, not just the docket. When they say public record, he is like, no, the docket is public record. What's in the media is not. But the thing is what's in the docket and what's in the media are one and the same for everybody.
Yeah.
Like the allegations in the media, you guys think about how many people, like how many media companies or, you know, organizations have come out here and given information they said came from an anonymous tip that is some theory, like the surveillance, like Bryan Kohberger supposedly installing security cameras in a neighbor's house because he broke in ahead of time to make her feel threatened so that she would ask him for help so that he could install security cameras and spy on her.
Yeah.
Like this whole ridiculous scenario, or the whole body cam footage of the girl finding underwear in her cup holder, and it's body cam footage of a white car driving by. Oh my gosh, it has to be Bryan Kohberger.
Yeah.
He's stalking her.
Yeah.
That theory. Okay. What about the theory that his sisters knew it was him and went and searched his car, and his family suspected him the whole time?
Yeah.
These are things that Nancy Grace, so many mainstream media people, and some content creators go around stating as fact to point towards his guilt. And there's zero evidence, period. All the people that I've seen for the majority, and I'm not saying everyone, there's plenty of people I'm sure that lean towards guilt, not because of those things, but they're hard to ignore. And one thing the expert kept saying that really resonated with me, because I've been feeling this way this whole time, so maybe it's a bit of confirmation bias, is people can't compartmentalize when they know something like that.
Yeah.
If they have heard that Bryan Kohberger's sisters knew it was him and he was wearing gloves at his house, and they went and searched his car, and, you know, he broke into some girl's house so that he could install security camera footage in there and spy on her, and all of these things, if they know those things ahead of time and have heard them all over the place and multiple mainstream media, whatever channels, it's hard to put that out of your head. You're going to already be tainted in the way you're looking at this man. And I think it takes very certain type of individuals to go into a like a jury like this and be able to do that, to remain totally objective.
Yeah, I agree with you.
Which is why I have felt personally it's important to have the other side out here in non-biased theories, contrary theories to guilt. Like, I think because we live in an age where it's just not possible to have everything closed off and have people not speculate or talk about it anymore.
Yeah.
So we have to make a concerted effort to make it balanced.
We do. No, we absolutely do.
And to make sure people know what's in court documents and what's not.
Yeah, no, absolutely. Absolutely. I agree with you. I agree with you 100%. And, you know, when I was watching this hearing, there were a couple things that, that stood out when, not only does the lack of information, but the difference in what the expectation is with including the general public or population in that area versus what we're seeing from the defense's expectation, in my opinion, is very, very, very different. And like where I'm going with that is there's a video out there that talks about Idaho, and it talks about Idaho and how one of the major downfalls in Idaho is that Idaho's local governments are very secretive intentionally, okay? So then when you're looking at a case like this, it makes total and complete sense in that area that this local government is expecting to be secretive, because almost every piece of information and or evidence that's coming out, like these surveys we're seeing, they don't want out there. They don't want out there. And they're doing anything they can to try and control them from getting out there.
Dude, I gotta be a little bit honest. If Judge does not approve this survey process, I'm gonna have really big questions about his ability to be a fair judge in this case.
Yeah.
Like, I think it needs to be called into question if he does not approve it.
One thing that's interesting,
I think there needs to be a Supreme Court appeal if he does not approve it.
Yeah. Well, yeah.
I do. I think 100%. And I like Judge, but I think
I'm sitting here trying to
there's some
figure out
issues
how I feel about it, because that's assumed, like we're making an assumption that everything goes in the favor of the general public and is 100% fair. Like there's a lot of other information that can come into play there that could change the situation. So I don't know. I need to hear everything first. I literally need to hear everything first before
We
I
did
can
just
make a
hear
conclusion.
everything.
I mean,
we're waiting on his decision. There's not going to be another hearing on this matter until he makes a decision. Then they will do whatever they need to do unless they need another hearing after his decision. But there isn't supposed to be another hearing. It's we're waiting on his written decision, and then there's a change of venue hearing.
Right. But where I'm going with that is it's not going to be a yes or no answer.
Okay, but this was Bill Thompson's, this was his chance to provide any evidence refuting what the defense is bringing. And he brought none. He brought zero.
I hear you. I understand that. But just because there's no evidence doesn't make something not true. And that's something we've argued a lot in this case, too.
So what are you saying?
Just because maybe Bill Thompson became unprepared doesn't necessarily mean that that there's no evidence that something could have been done differently. So like, I'm always really careful, especially in a situation like this one, like right now, where I'm not making it seem like, what's it called when you're pro-burger? A pro-burger. I'm not a pro-burger, okay? So with Ann Taylor, were there a lot of areas that she could have done things very differently, that she could have changed things and not came at the judge sideways and not approach the situation, or could have approached the situation in a different way? Yes, absolutely. Like, I think the questions could have been worded differently, right? But the whole, just as an example, but that's with the understanding that there's no such thing as a perfect case. There's no such thing as a perfect anything. So, like, I want to hear the full ruling from Judge on what the determination is on this. It's not just a yes or no. Is it yes, we're going to do this in this way? Is it no, we're not going to do this in this way? Like, what is going to be the direction? You know what I mean?
Yeah, so I agree. I obviously want to read his full decision and his explanation for his decision. I am okay and agree with them adding a disclaimer before they ask these questions, saying none of these questions are an assertion of fact.
Yeah.
They do not indicate facts of this case. They are merely things purported in the media. Answer them honestly. There's no right answer. If they just say that, I think whatever's asked, as long as it's been disseminated in the media 1,000 times, like the expert was saying, it's not a big deal. None of it will bias a jury. And again, those questions are never asked unless the person recognizes the case, meaning they have watched the news and watched coverage on this case.
Yeah.
If they have not, they do not ever hear those questions.
Yeah.
That disclaimer, I think, could fix all of the issues. And I was really happy to hear the expert say, yeah, we could add something like that. And I think it's a good middle ground for everybody.
Yeah.
Though I don't think Bill will feel that way. I do think if there is by any chance an issue with it causing somebody to know something they didn't know before, or hear something they didn't hear before and could cause bias, I think that's a good way to hinder them believing, oh, because they're asking this, it's true.
Yeah. Yeah.
Like, oh, none of this is a statement of fact. It's just things being reported in the media. So that means there's things in here that probably aren't true. So I don't know what's true or false. But the thing is if somebody knows that much about the case, they know exactly what's in the PCA and they know all of these questions are true, then they're biased and they can't be a juror anyway.
I know. What's interesting is I agree with you. I agree with you. And I was just responding to a comment because I was literally feeling the same way that they're feeling. So they said, I kind of hate how hyped I got from this hearing. Yeah, I was feeling that same thing. Like, how ridiculous is it that we are
it's like a football game?
Yeah, that we're hyped up for our basic rights as human beings. Like, it's insane. And there were a couple pieces in there where I tried to call Ann Taylor out, because that comment she made where she asked the expert, I need water. That comment she made where she asked the expert, have you ever had one of your surveys stopped? That was an attack at the judge, in my opinion.
And he said no.
Yeah,
He said
he said no, but it wasn't needed. Is what I'm getting at.
I get it. His 15 years, he had never been stopped in his process of doing these surveys.
Yeah,
which even though I agree with you, it didn't need to be asked, but it's significant. It says something.
It's not. I don't think it's significant.
Oh, I think it is.
I don't, because all it's doing is putting the judge down.
Yeah, his name is Bryan Edelman. That was the expert, Dr. Bryan Edelman.
Yeah,
we pulled up his company the first time we heard his name when we read the motions.
Yeah.
Prior to this,
we had his picture up for a minute.
His company name is Trial Innovations. If you Google it, you can find the website, and there's a ton of information on there about him and the co-founder of the company and what they do. It's
You said co-founder.
Co-founder of the company, and what they do.
Yep, this is him. And
can you zoom in on his face a bit? It's kind of dark and small. There you go.
Boom. You can even tell if he has any
boogers.
Boogers, yeah.
Or ear hairs. But yeah, this whole thing, I understand feeling that way. Like, gosh, why are we getting so hyped for this? But look, it's absurd. The whole thing is just so absurd.
Yeah, I agree with you.
It feels like fighting for scraps.
Yeah. It is wild after what we just had to deal with last hearing. Absolutely insane.
Thank you so much, Steve, for the super chat.
Absolutely insane.
Mm-hmm.
So, and thank you. Huge shout out, Steve, saying Nancy Mace, which
Nancy Mace is Coco.
Yeah.
Sorry, had to say it.
Nancy Grace is crazy.
You didn't have to say it like that. You could have just let the comment be what it is.
Yeah, I got you, but
why do you got to state the obvious?
Because I do.
No.
Yeah.
You're supposed to not do that.
Look, the word crazy is relative to the person who's saying it. All right.
Okay. I'm a little crazy too, to be fair. So, yeah, the whole thing felt obviously better than the last hearing, because the last hearing was a soap opera, but this one, at least we got some actual evidence. At least we got to hear from the experts. But again, it still feels kind of like a soap opera a little bit. There were just less personal feelings this time.
I got to give a huge shout out though here. Hang on.
To who?
A big shout out. Okay.
What are you doing?
What?
What? You gotta blow it up pretty big. Oh God.
Okay. I gotta give a huge shout out to Judge John Judge. Okay. He put his foot down in a way in this hearing I have never seen him do.
Agreed, he did.
And it was done very nice. Like, when he put his foot down when Bill was objecting and he continued anyways, he never gave like an official ruling that like, yeah, we're going to continue. He just ignored him. He just ignored Bill's comments and continued. I wish I could have seen Judge John Judge while he was doing that, because it would help me understand him a little bit better. But I was happy to see it. I was like, okay.
So which part specifically?
So I think it was the first time that Bill Thompson gave an objection.
Okay.
During the expert hearing or the expert statement. I'm sorry.
Testimony. Yeah.
Yep, the expert testimony. And he stood up and was like, we just can't allow this. I can't believe I'm having to look at a screen to my left and listen to a man who's talking. Oh my gosh, you know?
Right. Like it's such a foreign thing. Like there's never been an exhibit in the court before. I can't judge. I can't make my eyes go two separate directions.
Yeah. Yeah. Absolutely crazy.
So
absolutely
stupid.
Crazy. So, but anyways, when he was saying that, hey, we just need to take it down, like we can't do this, I don't agree with continuing on this, Judge put his foot down and was like, yeah, we're continuing, you know?
Yep.
So yeah,
I did hear a part where he put his foot down, and I mean, even allowing the PowerPoint in the first place.
Yeah.
Was him saying, look, I got to see the evidence. I got to hear the evidence for myself. And I think, that's a huge shout out to you, Judge, for putting your foot down for once. I hope you keep it up and let them continue the survey. Even if you have a couple conditions, let them continue the way that it's like the way it needs to be done properly, the way research and, science backs.
Listen, I'm right there with you.
So,
I'm right there
and
with you.
I don't know. Judge should be able to look at the other cases this has been used in and see other examples and, go from there. And I assume he will do that to help make his decision.
Yeah.
But
yeah, I think so too. And I was just happy to see that he could control that situation. You know what I mean? I was just happy to see that he was able to control it. So
positive feedback here. I know that everyone very much feels like he can't put his foot down, but in that one instance, he did. He allowed the PowerPoint. He could have said, no, there's probably sensitive information in here. We'll just listen to the expert and not look at the PowerPoint. He could have very well said that. He did not have to allow that PowerPoint to be put up. He could have just went with Bill Thompson's wishes, but he didn't. He let the PowerPoint be put up. And guys, there kind of was information, I would assume, that Bill Thompson wouldn't want out there. The percentages of the survey. They put out data from the survey.
I'm going to have to chew on that. I know that I'm not going to be able to have a sound opinion right now. And I've shared with everyone before that I'm the type of person, I need to chew on something to be able to get a good understanding of both sides of the coin. I'm not somebody who can create like an opinion on one-sided information. I need to look at both sides. I need to understand both sides, and then I need to figure out where my opinion lands, somewhere in the middle. And that's one of the topics I was sitting there thinking of. I was like, I already know I'm not going to have opinion about why Bill Thompson is doing this in this way. I couldn't tell if Bill Thompson last hearing read the questions to bias all of Latah County. You know what I mean? I didn't know if that was the intent or if the intent was to stop these percentages from getting out into the public.
I think he read them to ruin the survey.
Yeah.
I think he literally read them to ruin, he thought in hopes that it would ruin the survey because everybody has the questions, like literally the public at large has the questions. So he thought they would no longer use those questions anymore.
Yeah.
And the expert even said, now that the questions are out there, I don't know how it's going to affect the results.
Yeah. Yeah.
because of this
Absolutely.
whole kerfuffle, you know?
Yeah.
So yeah, it may affect it slightly. I'm curious if they can mitigate it at all. But yeah, I think that was his intention, was to ruin their survey.
Yeah.
But that's
That's
just
what I was thinking
speculation right
too.
now. But I mean, obviously I don't know for sure. I just can't think of another reason he would read them. He's
Mhm.
claiming they violate the non-dissemination order. So why are you reading them and disseminating them further?
Yeah.
And then literally point blank saying one and picking that one in this hearing and saying Bryan Kohberger did not stalk one of the victims. It's false. Yeah, kerfuffle. I like that word. And you know, I saw somebody say when the judge doing his job is an exception instead of the rule, that's a major problem. I understand
Yeah.
feeling that way.
I agree.
I absolutely understand that. So far, I think he has done his job, even if we don't agree with the way he's done it. The fact of the matter is, judges are allowed to make decisions based off their own discretion. They can set precedents by making a choice that hasn't been made before.
Yeah.
It doesn't have
I
to
agree.
be like it can change. Like the way they do things can change. It doesn't have to even go with the standard always. Do they
Mhm.
like to go with the precedents that are already set usually? Yes, but in a unique situation they can change their mind, and that's why they have this discretion, because every case is unique. Do judges always use it in the best way? No, I don't think so. And I think in this situation we have a county of judges and lawyers who are not experienced in this kind of case at all. They have never had a case that is as high profile as this, that is a quadruple homicide with this much data. Okay. This many jurisdictions involved in a DP capital case. They just
Yeah.
haven't had anything like this. They have zero experience in it. Zero. None. Big goose egg. No experience.
Yeah.
So they don't know what they're doing exactly. They're learning as they go.
Yeah. Yeah. It doesn't need to be that way, though. It doesn't need to be that way because technically there's nothing new being done in this case.
No, this kind of thing's been done before in other states, but Idaho has really strange laws. Like, there's been so many like the whole alibi thing. I've seen so many people that think Bryan Kohberger is guilty make such a big deal of that alibi deadline. Dude, Idaho's the only state that I've heard lawyers literally say Idaho is the only state that has an alibi deadline. The only state. So then why is it such a big deal? Why is everybody acting like this leans towards guilt?
Yeah, I have no clue whatsoever.
Really weird.
20. Okay.
Tasmania.
What?
Idaho's the Tasmania of America.
Yeah. Yeah. I don't know. The whole thing is really strange, and I have a hard time with all of it. Just because I don't even know how to express like how insane it is to me, in my opinion, that Idaho thinks that it's okay to not share the public information with the general public in the area. I think that is a huge problem. I think that all it does is create issues and creates a separation where, like you said, they're desensitized to the law locally, and it does nothing good for anybody. And now we're seeing what happens in these court cases when the desensitization to these situations impacts a very public hearing. A very public hearing.
Mm-hmm. Yep.
I'm gonna have to rewatch the expert testimony.
I'm gonna
again
have to
because-
rewatch the whole thing.
Whew.
I'm gonna have to rewatch the whole thing because it's so much at once, and I feel like I missed a lot of little parts too, where I couldn't quite tell what they were saying.
Mhm.
I need better headphones. I was using my earbuds.
I feel like I heard everything pretty good.
I feel like
there
I'm
was
going
a f-
deaf.
There was
I
a f-
swear.
Yeah, you're going deaf.
I think I really
It's
am.
from how loud I talk. We're,
You're constantly
Yeah.
abusing my eardrums.
Yep, absolutely. That's the kind of abuse people are talking about. Makes total sense.
You're
now.
just too loud abusing my
Yeah.
eardrums.
Audio abuse.
Yes.
Yeah. No, it's super funny. That cracks me up. It always gives me a good day when I see those abuse comments. Really.
It brightens your
It
day to
does.
see that you're abusive
It
to
does.
me.
I love troll comments. Love them. Absolutely. Yeah, I mean, the only part that I don't think that I heard really well is the part where I was laughing so hard at Bill Thompson. I missed probably that full 10 minutes because of how hard I was laughing. It was hilarious.
Wait, which part was it? I was trying to remember because when it came back on, I was trying to remember the part that we were laughing so hard and so much happened. I just couldn't remember.
So it is the part where the expert, like, jokingly to Bill Thompson was like, well, Bill, like, what do you expect I would have done then? You expect me to ask a question with a wrong, like a not true question to create an unbiased poll? And after the question, you want me to say, oh, by the way, Mr. or Mrs. Person, that's not true. And Bill's like,
oh,
yeah. What? Are you kidding me?
It was so dumb.
After every question, it's supposed to be like, oh, by the way, we just want to let you know that's not true. Oh, customer, by the way, we want to let you know that part is true.
Right.
That's insane and completely and utterly not needed, like, at all.
Yeah.
At all.
The whole conversation after that was just hilarious.
And Bill Thompson's manipulation it's not even manipulation because it was so bad, okay? It was that bad where I just it was absurd. But when he started off the conversation saying stuff like, what did he say? What was the last one? The last one was, okay, let me say this. So I can have this situation start making sense again. Something like that.
Yeah.
Where he's trying
Let's
to
bring it back to reality.
Let's bring
now.
it back to reality. Yeah.
Something
so
like
he's
that.
trying to devalue everything said.
Or bring it back to center or something like that. It was something like that.
Everything said before him.
Right.
So offensive, dude.
It was
so offensive.
You know, what's the thing that Masseth said? Oh, the thing about the PCA. She said, and you know, there's things in that PCA that are flat out just not true.
Yeah.
I was like,
and it wasn't only that. She made the comment making it sound like there's multiple things that aren't true.
She said there's things with an S that are flat out not true.
Yep.
Whoa.
Yep.
Whoa, bro.
Crazy.
That was wild. I couldn't believe she said that. But to be honest, Bill Thompson was out here saying, oh, this specific thing wasn't true. She had every right to say it.
You know, Strange Suspicion was saying in the chat, and I haven't thought that it's going to go this direction, but she was saying that she thinks that it's going to end up being a mistrial. Okay. Then I started thinking,
did see her say
I started thinking, because sure, I've heard of that. Like I got it. You know what I mean?
It could be a hung jury or something too.
It could, but if they're able to throw the trial before any experts or evidence is shared, you know how upsetting this case would be in the true crime community? How nobody would get answers.
We would never get answers.
Never. With the house gone.
With the way that Idaho hides everything, with the home gone, so that private investigators and cold case detectives can't come in and re-examine everything. Like, yeah, we would never get answers. We would never know the true outcome of this case.
For sure.
Especially people that really believe Bryan Kohberger is innocent. I mean,
yeah, there you are.
Clearly. All of his attorneys feel that he's innocent.
It just, I'm glad you said that, because it just made me think like, okay, so what would be the value in that, right? Because A, they probably need to get past the Gonsalves lawsuit that they have, and B, they would never have to share any of their evidence, essentially saving the reputation of everybody.
Dude, do you remember in the beginning when they upgraded this to a death penalty case? When I said, did they increase? I literally asked this question. I said, did they increase the burden of proof so it would end up being a mistrial? That way it would.
That.
Yep. I was like, did they do that so that this would intentionally fail?
I've wondered that same thing. And I don't,
because you're right. It does save.
I don't understand.
It saves everyone's reputations because it will continue to be an active investigation, even if it's a cold case.
Yeah.
And they won't give us anything.
Yeah. Yeah. I agree. I agree with you. And I don't know. I'm not sure.
Yeah.
I'm not sure.
We can't taint what's already tainted. Exactly. Massive said that.
Yeah.
She said we can't taint what's already tainted.
Right.
That was a really good point.
Yeah.
Really good point. I don't know. The whole thing just like, why do you think that Ann and Massive came out and said, I bet you Logston was like just gritting his teeth to get in there and say something.
Yeah.
I really think he was. He's totally an attack dog.
Yeah.
But
I'm excited to see the
I don't think Ashley Jennings wanted any part of it.
No.
Though. She was like, I'm gonna stay way over here.
I'm excited to see how he does with the chains off.
Me too.
Logston, yeah.
Me too. So
he's the only one in that entire courtroom, in my opinion, that can grandstand effectively.
Oh, I think Massive can do it well too, but I think Logston probably would be the best at it. So why do you think Ann and Massive both said that they firmly believe in Bryan's innocence? And Massive went as far to say the whole defense team firmly believes in Bryan's innocence. Why do you think they chose this hearing to say that? Is it because their integrity is being called into question?
She's already said that.
Not like this. This was different.
Sure. Well, okay, she's said it personally before, but yes, now she has said it that I don't know if there's a reason we need to look into the why of that. Okay. Maybe at the time when she presented that, hey, I personally believe that Bryan Kohberger is innocent. She's now had enough conversations with his entire team to know everyone believes that, because I'll tell you, if I'm an attorney or I'm an investigator, one thing that I'm not going to do is ask what their opinions are, who I work with. I don't want to know. Because I feel like that's like bringing up politics, where I can respect anybody, dude. Somebody could have the most radical, insane beliefs, and I can work with them as a peer and have no problems. I don't care. Your beliefs are your own. It doesn't matter to me. I have my beliefs. You have yours. I can treat you like an adult. I can treat you like a human being, and I can care about you as that. But it doesn't mean I have to agree with your opinions. So in a situation where you're an attorney dealing in a case like this, I would just be shocked if they were like, hey, by the way, Logston, so what do you personally think? Do you personally yourself think that Bryan Kohberger is innocent? or not?
Yeah, I don't.
You
I
know what
think
I mean?
that would be kind of
would be
inappropriate
weird.
to ask that. So she also touched his shoulder when she was saying that she believed in his innocence. Do you make anything of that?
No, I don't.
You think it's grandstanding?
No,
You don't think it's to portray a certain thing, like I stand with him?
I think it
like,
could. I think that it could be grandstanding, or it could just be that is her. That's how she is. Okay, like personally, maybe she is somebody who greets people with a hug or an arm touch or something like that.
and
I can't tell the difference between the two. But maybe it was to present an image
to
that
sell her
she,
point, that she stands with her client.
Absolutely, selling it with physical contact.
I think it's a good way to do that. I don't find it weird at all. I don't find it inappropriate at all.
What are you talking about? Of course not.
Yeah,
You think some people will try and say that was inappropriate?
Yeah, I mean, I do. I think some people will feel that way.
It's not like she's trying to take off his shirt.
Dude, come on.
What do you mean?
Come on. People have zoomed in on Bryan's zipper, okay, and made a big deal of that and come up with all kinds of things because of that. So, yeah, I think people can take it and be like, oh, is that? I've heard people speculate that Bryan and Anne have an intimate relationship going on. It is absolutely absurd.
Yep. Crazy.
There's literally nothing to
Taylor's
indicate
married.
that.
I think that's just a way to bring.
She is married.
I think that's just a way to bring gossip attention to this case in general. I just pointless, whatever,
Yeah.
Yeah, it's more subjective information and focus.
Well, and there's no indication of it anyway. It is subjective focus. It's to discredit her. And I don't feel like it's fair. It's not fair at all.
No, it's not fair. It's not
like,
fair.
are we going to speculate Bill Thompson has a intimate relationship with Ashley Jennings because they sit a little too close?
I don't know. Yeah.
No.
It's just one way to keep people from focusing on the
what's important.
Yeah. The objective evidence, the objective data. Yeah, absolutely.
Yeah, and it is a way to try to make Bryan look worse too. Absolutely. I'll be right back, okay?
Yep. But gosh, you guys, I don't know if you saw where I was laughing. I haven't laughed that hard and I don't know how long. Literally my stomach hurts. My stomach is sore from laughing so hard. I couldn't stop because I feel like that was what got me laughing so hard is thinking about Bill Thompson and that statement where he responded to the expert like, yeah, I do expect you to do that after every question. I was dying because I feel like that was the only honest statement we got in the entire trial from him was that, yeah, everything, his micro expressions, his body language, his tone, he meant it. And the expert was joking around, was saying, oh, so what do you expect me to do? You expect me to ask a question and then give the answer after every question? Joking, So yeah, it was hilarious. I'm gonna have to pull that little piece where he did that and turn it into a short or something. It'll be great. But I don't know, you guys. This whole hearing, look, the pro, the good, the positive, I guess heads isn't always the positive. Okay, so one side of the coin. You guys know what I'm talking about. One side of the coin here. Is that I feel like we're finally back into a normal trial again. And I know I said this just a little bit ago, but after the last hearing, I've got to be honest, I was worried. I was concerned. I had no idea if this is going to be the expectation that we're going to see going forward, that, it's going to be nonstop, just soap opera. Well, Judge, I don't feel like, why is the word feel in court at all, unless it's an evidentiary basis trying to present a, statistical probabilities or assertions or anything of that nature. And I feel like every time, and then I say, I feel like every time Bill Thompson makes a statement, it's an I feel statement. And it's still interesting that he's making statements and then coming out and saying things like, well, it's not Ann Taylor. It's not Ann Taylor. Ann Taylor herself didn't violate the dissemination order, but the defense did, but not Ann Taylor. Weird. That was said this hearing, strange. I don't get it. I have no idea. But I'm just glad it's back to some semblance of normal. And I hope that did you guys notice how empty the courtroom was? Nobody was in there. Nobody. I think I saw like 3 or 4 people in that courtroom other than the defense and the prosecution. Strange, right? But I hope one of the major concerns that I have in this case is that the victims' families are being misled. Okay. They're being misled because of a professional motive, right? So Bill Thompson wants this win. There's no way, shape, or, argument about it. He wants this win. He's at the end of his career, and Ann Taylor wants this win. Okay. Anybody who tries to make it seem like, hey, they don't really care about winning or losing, they're here for Bryan's rights. Okay, get out of here. That's not how it works. And that's okay. That's just how our judicial system is built, is we have 2 sides, one for each argument, and they both want to win. That's fine, right? Well, I'm worried for the victims' families that they're being misled for the prosecution's career motives. And they're going to be misled for not multiple years to come to have this eventuality of Bryan Kohberger being let out and them having no idea. Can you imagine being a father of one of these victims and being told the information you were told leads you to believe this man did it, and this man did it alone, and he did it with such violence and ferocity that he is an absolute and total monster, and we don't need to look at anything else except shooting him, okay? And then that man gets let out by something like a mistrial or, whatever the 5 different things that can happen in that case that could get him let out. I'm now in I think that would be a scary situation. Scary situation.
I was
out here.
Okay.
So super sticker KK coming through. That is awesome.
Yes,
we
thank
appreciate you. Thank you. Thank you.
Thank you very much. The whole time I was thinking, what is Bryan Kohberger feeling?
Listen,
and to be honest, I feel really bad for the victims. I don't know.
70.
It's kind of a joke. And
yeah,
like,
I agree.
They have this non-dissemination order, and the judge, there for a while, we didn't know if there was going to be cameras in the courtroom. And he said he wanted to avoid it being a circus like the OJ trial. Well, this kind of stuff kind of makes it look like a circus, and it's not because of cameras in the courtroom.
Yeah, I got to be honest with you, though. I went back and I watched some of the OJ clips, and those lawyers were pretty dang professional.
I agree.
And they knew what they were doing. Now, when you put those lawyers in front of a camera, like a mainstream media camera, okay, things changed. Like things got a little bit wild. But I gotta go to the bathroom.
Okay. No, I mean, I think the circusry of it was not just about like the lawyers being unprofessional or anything. I think they were professional. I think it was just the media attention is really what they're talking about. Everything was dramatized, like to the nth degree in the media because of the nature of the case and OJ being a celebrity. No worries, Strange Suspicion. Thanks for being here. Hope you have a great night. Again, shout out to her. She's a content creator. If you haven't checked her out, definitely do so. She covers Idaho 4 quite a lot. I love Andrea Burkhart. I'm looking forward to going and seeing her commentary after the stream, or probably tomorrow, and see what she had to say about all of it. I did see somebody say in the chat that she said that Judge is pretty much the best you're going to get in a small Idaho town. She's probably right. She speaks about small towns in Idaho quite a bit. She brings it up and how it affects court cases, and I can see it, especially recognizing it from my experience in small town courts. They just all know each other, like there's rapport built and things like that. So, and they just have a certain way of doing things, like, and they don't usually, small towns don't like when people come in and ruffle the what is the term, you guys? I'm always trying to use some like cute little saying and I forget what it is. I don't know why. Ruffle the leaves, right? I think that's what the saying is. They just don't like things to get shook up, they don't like change. They like things to stay the way they are. Oh yes, ruffle feathers. Thank you. I was waiting for somebody to save me. Hello to people in Tennessee. I'm not sure what the name is, but hello. What is it? Cat and it looks like Fla? I'm not sure. But hello. I forgot how to say ruffle feathers.
Okay. Let me go back to my
Okay, what were you on?
notes here. I was just spitballing it. Okay. We went through that.
Yeah. We talked data. You weren't very interested in it seemed like.
No, I was interested in it. I just had to deal with the madness going on in the chat. Data is literally my favorite. That is my strength. My strength is in the data. All I've dealt with my whole life is P&Ls, statistics. That is where my love is at.
Hello, Flash Cat from Tennessee. So what did you think? So the slide you're on, isn't that like prejudicial statements like from media?
Yep. So he talks about, I want to post this one here. Hang on. Yeah, it's a good one.
What are you doing? Oh, you're sharing it? Okay.
Yes.
Well, that's this prejudicial information supposedly is why I was talking about like the responsibility of media. Like, should everybody be out here just reading court documents word for word and giving no opinion? I just don't feel like it's possible or reasonable to expect that. Do I think the media has gone overboard in this case? Yeah, especially since they're not just reporting from documents, they're taking anonymous tips and rumor from everywhere.
Of course.
Instead of only focusing on the documented so-called facts, which, as Masseth stated, that there's things in the PCA that are not fact. Like Bill Thompson keeps
That's where I was
saying
going. Yeah.
they're facts.
Yeah.
All of these are facts, and this is a not true fact, and this is a true fact. And you guys, we've had lots of conversations on this channel about what is a fact, what is a theory, scientifically, and all of that mess, and what's like subjective versus objective and things like that.
Yep.
And I think it's important to clarify that none of these are facts as far as I'm concerned, or anyone else, because
agreed.
this is all a hypothesis of this case. It's not even a theory.
Yeah.
It's a hypothesis.
Everything runs off of theories. That includes law enforcement. Law enforcement is just creating their best theory possible based on the evidence at hand. What's interesting is that law enforcement wants you to believe that that they know it all. Okay. And you can see that in this case. This case is specific to it, that they want you to believe that they got it all down and they know exactly what they're doing and everything they're saying is true. And you need to believe everything that comes out of our mouths, when what's interesting and what we're hearing is that it is not the case. That is not the case at all in this situation. Because Bill didn't come up in front of everyone and say, hey, that is not true. Actually, everything in the PCA is fact.
Yeah, that's how he acts. And I mean, that's what he said in his statement initially in that press conference they're talking about that they played on one of the slides. Is he says, spread, like, once Kohberger's here and they can give out the PCA or whatever, take the facts of this case and spread them far and wide to your readers and listeners and people that are interested in this case. He literally said the PCA is the facts of the case.
Yep.
That is really interesting that he chose those words.
Yeah.
Those really came back to bite him in the butt. And I think at that point, I feel like Judge really was taken back by that.
Yeah.
That they played that in the courtroom.
Maybe.
His face, man. His face.
But yeah, I agree with you. Like I've said from the beginning, that the PCA is a theory. You're right. And exactly the point of like what I was saying with law enforcement is law enforcement runs off of theories.
Yeah, they're speculating. They're going off of evidence and they're speculating. And I mean, it's not as objective as they make it seem. You know what I mean?
Yep. Absolutely.
It's just not.
Absolutely. But so this is where he was talking about the source of the media prejudicial. The source of the most prejudicial media items came from the arrest affidavit, what we're talking about, which the government chose to file unsealed with the court. Xana and Ethan found on the second floor, Maddie and Kaylee in bed together on third floor.
They're considering that prejudicial?
I guess. Wouldn't it be crazy if none of this is true?
Dude, I mean, Masseth literally said there are many things in this PCA that are flat out not true. So what do we actually even know about this case, you guys? What do we even know? Did they put things that weren't true on purpose in this PCA to mislead the public? And because it's not an official PCA, because he wasn't arrested in Idaho, it's only an affidavit attached to a PCA in another state.
I feel like
So it's some kind of legal loophole where they can be a little bit dishonest.
I feel like that's a that is
that tin hat?
No, that's a very good faith approach.
What?
And assuming that the law enforcement put the PCA out with the intent of misleading the public, I tend to believe that they investigated like this. And that everything in the
think they did
PCA
too.
is what they truly think happened. And I don't know if that's going to end up being the case.
And then their evidence is proving that's not what happened.
Yep.
Maybe.
Yep.
Maybe. It could be that.
So I would just be shocked if they came out and had approached the PCA in such a dishonest, bad faith way. Like I would be.
I mean, Bill Thompson's statement there shows
that's
you
Idaho third world.
they were
like, you know,
yeah, they were
Jeez.
looking for Bill Thompson and the investigators were literally looking forward to putting this PCA out. And that statement by Bill Thompson proves it.
Yeah. Yeah.
So what else is listed on there? The knife sheath being found next to Maddie.
Yep.
Idaho State Lab found single source of male
I don't
DNA
really
on
understand
button
how
of
that's
sheath.
prejudicial, but okay.
They basically said the PCA was prejudicial.
Yeah.
Compared that DNA to trash they took from Kohberger family home in Pennsylvania on December 27th. Matched the DNA of the suspect's father almost 100%. So wait, are these
partial and
what if
ambiguous?
wait.
What?
I mean,
What?
well, no, because this is what the expert calls out. For a second, I was going to speculate, but I think I'm wrong doing that because this isn't the defense. This is the expert pulling these things out and saying,
Yeah.
these could be prejudicial.
Yeah. Absolutely. Absolutely. So matched father's DNA almost 100%. Okay. So then we have phone didn't ping towers near King Road house. Investigators believe he turned it off, but then pinged on the way back to Moscow after the murders.
So phone didn't ping the towers near the King Road house. Investigators believed he turned it off, but then pinged on his way back to Moscow after the murders. Okay, that has to be some kind of typo.
Yeah.
He must mean back to Pullman.
Yeah.
And
Yeah, that's strange, but phone records match Hyundai Elantra movements. I mean, whoa.
they indicate that that's why the trip
Yeah,
to
they
Albertsons
indicate
and
he's driving.
yeah. So when he first starts driving, also when he does that next day trip down to Albertsons, that's why that part is important, is because they're trying to use that because they have actual video evidence of him being at that store
Sure.
and things like that to prove that the cell phone records are showing where he actually was. They're trying to use that as a way to say our cell phone data is accurate when it's in a totally different city and
Got it,
town.
got
Like,
it. Yeah.
so it doesn't
different
matter.
coverage, different everything. I
Yeah.
got you. Yeah. Okay. Yep. So if you guys didn't understand that, which you probably did, but what she's saying is like
mansplain what I just explained.
Yeah. So the towers, so there's going to be different coverage in Moscow as there is, what is that town south?
Clarkston, Lewiston area.
Clarkston, Lewiston area. And the coverage in Moscow sucks. Like
It's
it
horrible.
is literally
It's definitely better in Clarkston and Lewiston based off of how many towers are
like
down there.
way better.
Yeah, a million times
You
better.
could literally triangulate in that southern area
in
for
those
sure.
in that city, yeah.
In Moscow, you cannot at all, period. No triangulation. There are not 3 towers that overlap, and then you need a 4th for verification. So using that Clarkston tower data to prove that the Moscow tower data is reliable is a gross manipulation. Horrible. And super chat from Translucent. We appreciate that. I think Payne made a UTC time conversion mistake in the times and the PCA.
Okay.
Yeah. It totally could be. And that's a good call out. Someone had mentioned that. Maybe it was you mentioning that in our comments before, but I looked into that and it totally could be. It totally could be.
I mean, I think it's possible.
Strange, you know?
Yeah, it would be super strange. But thank you for the super chat.
Yeah, absolutely.
Appreciate it.
And great call out.
Yeah. I think it is possible based off of what we've seen.
Officer says he later learned through cell phone records from June to December, Kohberger had been by the King Road home at least 12 times prior to the murders, most in evening or early morning. Yup. So if any of these are the most prejudicial, I'm telling you, it's those phone records. It's probably why we have a lot of issues with our YouTube, because we've been out here talking about how false anything cell tower related is in this case. It is impossible.
Yeah, somebody's got it out for us.
It's impossible that any of those phone records can be real. Impossible.
Yeah.
And anybody that has any amount of network experience and data and information
and is honest.
Yeah, and is honest will know that right away. Boom, right away.
I agree.
They cannot get him on triangulation. It is impossible. And they're updating the network right now in the Moscow area.
So the test can't be done now.
But the test results cannot be used that are now, since the update started happening from November of 2022.
Dude, they do updates constantly. So even if it was a month later, it's still going to be off a little bit. Now, a whole year and some change, that is something else, especially when they're supposed to be doing an overhaul.
The cell tower data is the most prejudicial, in my opinion.
I agree. I think it is too.
Most,
because it's supposed to show this repeated effort to stalk.
Yeah.
And that shows escalation. There's not a single other thing that we've seen that shows any type of escalation or intent, because we know that nobody could just come across this house and never have been in it before and do what happened here.
Yeah.
Effectively.
Yeah.
You should zoom in just a little bit more. We don't need to see the left side of like the document. Yeah, there you go.
Okay, so surveillance video showed the white Hyundai near crime scene multiple times around time of the murders. You know, it was Greg. Greg sent me some awesome information that I've got to verify before I talk about it on here.
Okay.
So shout out to Greg.
I did see him saying something about it, actually, now that I recall.
Yeah, talking about the camera that was at the corner store, whatever, that supposedly caught the infamous Elantra picture. You know what I mean?
Yeah.
And he pulled the information for it, and it says in there, and I haven't verified anything. I'm just taking it at face value here. It says in there that camera supposedly can save for over a month. So why didn't the cops get it?
Why did they wait?
Why did they wait?
And lose the footage?
Interesting, right?
It is because they were contacted. Somebody literally said, I looked through all this footage and I found something you need to see because it's at around the right time and it's the right type of car. So, and they literally waited and lost it. It makes no sense. But you know what also doesn't make sense to me? Why wouldn't that person record it and save it? Why would they wait and let it lapse?
I have no idea. I wish I was I wish I was a fly on the wall when the cops were talking to whoever that was. And for those of you that are watching,
does
hang
the
on
video
here.
indicate something that is not damning to Bryan Kohberger, but exculpatory to Bryan Kohberger? Is that car a different type of car?
Yeah. Or that that
So
gas
they
station
buried
technician, it just straight up lied.
Lied.
Or made it up to try to
Yeah, maybe.
And for any of you watching, make sure you guys hit that like button. Make sure you subscribe. Make sure you turn on your notifications and make sure that you join our social media. We're on everything. We are on Twitter. We are on Facebook. We are on X. We are on Instagram. We are on Discord. And yes, we have a free tier. We are on on Discord, it's always free. We are on Patreon, and yes, we have a free tier. And everything else, Reddit and everything in between. You can find us at /Thought Riot Podcast, spelt all the way out, /Thought Riot Podcast, spelt all the way out. But I am putting the link for that video I was just talking about in the chat here. So all you thousands of people can check it out. And it's a good one. It's a really good one. I was so blown away by that evidence and video.
Yeah, the link to the video that Brendan just put in chat is about the lost gas station footage.
Yes, it is.
And it is mind-blowing. It's a game changer for me. It's just a huge deal for me. It really shows incompetency or just like neglecting.
It's this one right here, you guys.
Yeah, it's just, I don't know. It's either intentional or you're just not competent. Like, you know?
Yep, absolutely.
I don't know how else you would say it.
I have no idea. I don't know. I don't understand it. I'm lost through the whole thing. I just don't get it. And yeah, it feels like incompetence. But I'm interested to hear, some of the details as the case proceeds and we get more evidence and everything in between. You know what I mean? So it'll definitely be interesting. No OnlyFans, but we have talked about doing true crime nude. No, just kidding. But on Patreon, we have a free tier. You can join us on there. And man, maybe we should do a non-nude OnlyFans. That would be a good idea.
I mean, it's just a Patreon then, and we have Patreon. OnlyFans isn't only for that type of content. It is actually used for like trainers,
everything.
Like trainers use
There's
it.
Literally everything on OnlyFans.
Yeah, like in any type of content creator can use it and provide paid content just like Patreon.
Yep. But there is also that too. So
yeah, it is heavily used, obviously, for what we all know it's used for too.
Yep. Which, no shame. I mean, I got nothing against it at all. So November 29th, Washington State University police learned Kohberger owned a white Hyundai Elantra. Did you hear that one?
No, sorry.
November 29th, Washington State University police learned Kohberger owned a white Hyundai Elantra.
Yeah, we've heard that stated before.
Yeah, we have, but there's nothing that is like confirming.
Yep. Just an officer saying he wanted to drive around and look.
Yeah.
And he found Kohberger's white Hyundai Elantra.
Yep. And physical description from Kohberger's driver's license matched the one the roommate gave. Huh? Physical description from Kohberger's
Dylan Mortensen's description.
Okay.
Dylan's description matches Kohberger's license picture.
Yeah.
Is what the claim is. Yeah.
I got you now. I was thinking like his roommate. I was just thinking of it wrong.
I mean, to be honest, she gave the most generic average description. So there's probably like 10,000 other young men it would have fit
Right.
in the area.
Right. Yeah.
You know, above 5'10", bushy eyebrows. She didn't even say if he was white or black
Mhm.
from what we saw in the BCA or what color his hair was.
Yeah.
Literally nothing identifying other than bushy eyebrows and above 5'10".
Yeah. Yep. Yep. Yep.
So
It's interesting. It's interesting for sure.
eye color bushy.
Eye color bushy.
That's super funny.
That is. But I can't wait to talk about this more after I've had time to chew on it too, because my mind always works better when I'm like busy doing something and it's just sitting back there thinking, you know, I'm just chewing it up in my head.
Sure, yeah.
So
I want to go see what Andrea Burkhart thought of this hearing, since we actually got to hear from the expert. That was her big thing from the last hearing, was we need to hear from the expert.
yeah.
And I agree.
Mhm.
I'm curious what she has to say about it.
Yeah, I am too. I am too.
You know what's really funny to me is like, I'm just gonna have to go back and pull the part to show what I'm talking about. But in the beginning, Judge says, "Oh, I'm not gonna violate you for violating the non-dissemination order or anything like that. Don't worry about that." And at the end, he brings it back up about the ethics and, you know, how this non-dissemination order is really at the heart or the ethics or morals or something like that of the Idaho judicial system and the lawyers in this room who have fought to keep information out of the media.
Yeah.
And I was thinking, and I don't know, the way he brought it back up, I was like, wait, I don't know, something about it. I'm gonna have to pull it back up and look back at it.
Like there was some kind of information attached to it that he wanted to continue pursuing.
Yeah. Almost.
Yeah.
I don't know.
But was unsure. I know what you're talking about. Yeah. I feel like there's been quite a few different situations in this case where they will start to talk about something and then they're like, oh, wait, maybe. And it feels like what they're saying is, without saying it, obviously, but it feels like what they're saying is like, should this be something that we should be talking about behind closed doors? You know?
Yeah.
That's what it feels like to me, because a lot of times when I hear that, exactly what you're talking about, I will think, how many conversations are these guys having behind closed doors?
Right.
You know what I mean?
Right.
How much of this stuff are they figuring out before they come into the courtroom? It makes me wonder, because of how many eyes they have on them. Like, does the Idaho judicial system allow enough room for these three to come together and be like, hey, can we like set a baseline for our hearing before we actually go out there in front of the entire world? You know what I mean?
Right. No kidding. No kidding.
But yeah, it's interesting. It's interesting. I'm excited to chew on it some more. I was excited to watch it all with all of you. I'm gonna put the links in here for everybody.
It was memorable, that's for sure.
Yes, you guys are all awesome, and we appreciate every single one of you, including the people that don't appreciate us. We appreciate you and hope everything good that you want in life comes to you. All right.
Yeah. And AR Hayes, I'm really sorry to hear that. He
What?
said he's been on dialysis for 15 years and it's starting to fail. And so he's looking at other options right now.
Oh, wow, dude.
That's got to be really difficult to go through. I want, like, can't they give you a kidney transplant? Isn't it kidneys, right?
I've never needed an
dialysis. Yeah. It's where they're filtering your blood because your kidneys aren't doing the job.
Yeah, I know what it is. I'm just saying that I've never been on like a transplant list, so I don't know what kind of things are offered out there.
Yeah,
but, you
everybody
know,
keep him in your thoughts.
Yeah.
Definitely prayers for AR Hayes.
positive thoughts, sending for sure. So
that's rough, man. And
yeah.
I just hope for a miracle, you know.
Yeah.
Diabetics can't do transplants. Is that the immune response or something? Is
Ooh, that's scary. I didn't know that because I'm a diabetic.
I know there's some medications that help prevent you from like rejecting something too. And they need you like with transplants, they make sure it's like as close to your genetic makeup as possible, things like that. I didn't know that. I didn't know that you couldn't get a transplant as a diabetic.
Yeah,
Well,
that's wild. But
maybe they can
sending
grow
all the positive thoughts your way.
grow
For
you
sure.
a lab grown kidney that's your own kidney.
I think once they're doing lab grown body parts, I think kidney's one of the first ones they're going to be able to do because of how it works. Like I could be wrong. I could be so far off here. That is not the science I'm in, you guys.
Well, I
I'm in
hope they
completely
do
different
something
science.
like that very soon. Let's just put it that way. Because
I
you think
agree.
about how helpful that would be.
It massive, huge, absolutely. And we just posted our Twitter in there, you guys. I think I posted our Patreon. I'm not sure actually. But just remember our Patreon, we have a free tier. You can hop on there and get alerts. You can hop on Discord. And if you don't know what Discord is or what you're doing on there, like if you get on Discord and you're like, whoa, what is going on here? I always suggest to people that you watch a YouTube video, just hop on YouTube and look at, you know, Discord walkthrough, and they're pretty good about it. And they will, you know, give you the walkthrough on how to use it at minimum. And I always tell people just, you know, be safe online, be safe online. All this technology experience I have, all this network experience I have, you know, a lot of people out there aren't open, like, you know, like we choose to be online with ourselves and stuff like that. So, you know, so for everyone else, don't share personal information. And if you ever aren't sure, I always suggest you look on Google, you know? So
yeah, people are offering to donate you their kidneys now.
Oh, that is awesome.
That is incredible. Somebody would be so willing to do something like that. Like,
yeah.
But there's a lot of great people out here. But yes, please, positive thoughts towards AR Hayes. And I really hope the best for you. I hope that they can figure something out that will work for you, because that's, I don't know, I just can't imagine. That's hard. It's really rough. But, you know, they're doing a lot of really innovative things. So hopefully they can come up with something.
Yeah, I agree. And I am going to pop our YouTube in here for all the other platforms we're on. There are a couple that are getting way more views than YouTube. And it's bringing people over to YouTube, which is great because a lot of the chatting happens on YouTube. So I just posted the YouTube link in here too, for all of you guys. So you can come check it out and chat on YouTube. But yeah.
Yes, have a great night, everyone. Thank you for being here. We appreciate you hanging in here with us and watching the hearing and going through all of this madness that is this case, I swear.
Yep, absolutely.
We appreciate it
all
a ton.
of you. You are all awesome. Every single one of you. Like I said, every person matters. And even for the people that don't really appreciate us, I appreciate you guys, and I hope the best for you. I only want the best for every human being out there. And, you know, the world needs more love, needs more care, needs more concern, needs more support for the neighbors to your left and to your right. So, you know, I'm offering that to you. So we appreciate you, and we will see you next one.
Yep. See you later.